right. We should be good to go with the Zoom. Ms. Rivers, good morning. Can you hear us?
Good morning. Yes, I can. Happy Friday.
Great. Ms. Jackson, good morning. What we're doing this morning is a continuation of an immunity hearing. And I don't think there'll be any dispositions of cases. So if you want to rejoin at a little after 1, that's when we've got a final plea calendar. So you're welcome to stay on, but if you've got other things you need to do, if you could be back with us a little after 1 o'clock today, we may have some pleas on the final plea calendar. Right. Hopefully she heard that. Let's get on the record. This is 23 SC 187742. It's State versus Esposito. We have Mr. Watkins and team here for the state. As always, Ms. Palmer and her client are here today for Mr. Esposito. Good morning to all of you. And my understanding is that what we've got at a minimum today is the state's final witness, which will be Mr. Moya. Maybe that's changed, but that was the plan. I think what you had represented, Mr. Watkins, and it wasn't binding, is that that would be the conclusion of your presentation, at which time I turned back to Ms. Palmer to see if there was anything she was going to put on as well. Am I remembering correctly? Have things changed? Where are we from the state side?
You're remembering correctly. However, I notified your office that we will not be calling any more witnesses. Okay. And that if we will be prepared for closing arguments today. I couldn't speak for the defense.
Got it. Okay. 100% your call. That'll streamline things at least a bit, because then you've concluded through Ms. Moya, that was the conclusion of your evidentiary presentation.
That's correct.
Got it. Okay. Ms. Palmer, that's news to me. Maybe that Ms. Nelson was told that. Didn't filter down to me. Doesn't change anything. We're starting at 9 today anyway. So that just means we've got a little more time to work with this morning. Tell me if you're going to put on any, I guess we call it rebuttal evidence now, or if you think that the record is closed.
We have no rebuttal case, Your Honor, and the record is closed.
Okay. So we're clear on the record. Obviously, the witnesses who've testified have testified. So that part of the record is complete. I still have the 2 thumb drives. I think Mr. Watkins, I think it was you, meaning the state, supplemented the thumb drive because you had added something that you thought was on there and wasn't, and maybe there was a renumbering. But I think with these 2 thumb drives, I should have all of the defense exhibits as well as the state exhibits. The key parts of which I think were the body cam videos, and those are definitely on there. But let me just check the exhibit list. So the defense exhibit list, it's a bunch of videos, some CVs, use of some policies from City of Alpharetta. I know both sides were using those. And then a little bit more paperwork, the 911 call, the CAD. On the state side, incident reports, photographs that I think came in through Ms. Moya. They're labeled Moya photographs. They were photographs, I think, of Mr. Moya. And then the CV for Dr. Adams. I don't have circled. If they're on the thumb drive and people don't mind, I'll have them. You had some medical records that you were potentially going to tender. I don't think you did. So if that's on the thumb drive and the defense doesn't want me to look at the medical records, I'm not saying I would, but my eyeballs might run across them, then we should take them off the thumb drive. What does the thumb drive have on it?
It does have one which you referenced. It also has a canine purchase order, the medical records as you just mentioned.
It has 1 through 18.
Correct.
Okay.
Correct. And we will not be seeking to introduce anything.
Okay.
Other than what's already been admitted.
Which I have for you is 1, 3 through 14, and 18.
Correct.
Okay. Ms. Palmer, are you okay that the thumb drive has these other things? I won't look at the medical records. There's not a dispute that Mr. Moya was bitten and it was a pretty serious injury. People went back and forth about how serious is, but that's really not what is the focus of. Was it a authorized use of force? Does immunity apply, et cetera? So you've got no issues with me just keeping the state's thumb drive?
I have no issues with that.
Okay, and I think with yours, exhibit 8 and 18, I didn't circle. So one is photos of wound, which may be the same as states 5 through 14. And then 18, you had labeled as Benfield body worn camera. So I had those as not admitted. Doesn't mean you didn't and I just missed it. Do you have the same list?
I do.
Okay. Does your thumb drive have 8 and 18 on there?
It does.
Okay. I'll just handle it the same way. I'll only look at the exhibits that were admitted. If for some reason, as I'm thinking through this, I think it becomes really important, for example, to look at the medical records, I'd reach out to both sides to see, is there an issue? Can I make those part of the record? But otherwise, I understand which exhibits have been admitted. So it sounds like if both sides want an opportunity to argue, to me, not with each other, the merits of the immunity motion and the reasons why it ought not to be granted, now's the time. So Ms. Palmer, as the movant, I'll let you go first, and then you can also have the last word after Mr. Watkins or one of his colleagues has presented the state's perspective.
Thank you, Your Honor. As you know, we brought this motion under the state's immunity statute 16-321, arguing that Michael Esposito, my client, was justified in using force against Travis Moya because he reasonably believed that the force was necessary to defend against Mr. Moya's imminent use of unlawful force. And over the course of our 2 previous hearings, we've shown by competent and credible evidence and testimony that we have met our burden of a preponderance of the evidence under the relevant statutes, and that this case should not proceed, that Mr. Esposito should be immune from prosecution. I believe we've gone beyond a preponderance of the evidence in making this showing. On the day in question, Michael Esposito was on patrol with the Alpharetta Police Department, and he responded to a call at Lunetta Lane, which we know from Defense 16, the CAD report, was described to patrol officers as chief complaint, domestic disturbance/violence. Law enforcement officers are trained to know that domestic disturbances are dangerous, and in a situation like this one, where Mr. Esposito knew from the CAD notes before arriving that a firearm, a handgun, was in the home, could even be deadly. We also see from the CAD, again, Defense 16, and Officer Esposito testified to this, that he saw the notes which indicated that the caller had said his stepfather was punching things, growling, and acting wild. We know from Defense 2, Mr. Esposito's body-worn camera, that when Officer Esposito arrived on scene, he spoke to Travis Moya in a calm tone. He said, "How's it going, man? Calm down. We're just here to help."
Why? Tell me why you think it matters that Officer Esposito started out calm as opposed to starting out, "Whoa, I'm concerned," and yelling and which he didn't. You are sharing with me what I believe the record shows, that Officer Esposito showed up calm, at a distance, trying to assess the situation, and de-escalate may be the wrong word, because it's not that he came across a fight at that moment, but he came across someone who appeared to be agitated. But why does all that lead in matter? He didn't come in, no, I don't mean the guns blazing like he actually had his gun out, but he could have zoomed right up on the guy and said, "You need to get on the ground," based on domestic violence situation, firearm in the house, stepdad punching things, etc.
It goes directly to his reasonableness, and that's what we have to consider. What a reasonable officer or a person in this situation would see with the circumstances before him. And what we have made clear through a number of exhibits, including Defense Exhibit 2, is that Officer Esposito was in a reasonable state, behaving as a reasonable person, taking in all of these details, facts, and circumstances around him, and doing exactly what we would hope an officer would do in that situation. So you hear this, you see this from what's been admitted as defense 2, and you can also see what he is perceiving, the circumstances on scene. You can see Travis Moya's wife, Cami Moya, his daughter, and the suspect, Travis Moya, are all outside. And Travis Moya is back by the garage, and you can see Cami Moya trying to reason with him. And you hear Travis Moya yell to Officer Esposito, "Nobody called you. Nobody called you." And then you hear Officer Esposito speak into his police radio, "Step it up. He's being disorderly." Cami Moya walks over to Officer Esposito, and she tells him that her son called 911 because he got scared. And she says, "I don't know if he took something," referencing Travis Moya, "but he's not his normal self. He's breathing hard." And again, at that moment, in the background, you hear Travis Moya yell, "I'm not fucking with you," and other profanities at Officer Esposito. At the 46-second mark, defense 2, Travis Moya starts walking closer to Officer Esposito, and Officer Esposito tells him to stay back. And Cami Moya yells, "Babe, stop." And you can still hear Travis Moya cursing loudly in the background, and he certainly does not stop. Cami Moya goes on to say to Officer Esposito that she thinks her husband may have had some bad weed and that he has never been like this before. And at 1 minute, 23 seconds, she says he is not in his right mind whatsoever. When asked by Officer Esposito, she confirms that he punched a wall outside the home, and she adds that he threw down a chair. So this corroborates what Officer Esposito saw in the CAD notes right around his arrival, that the suspect has engaged in violent behavior. That's in the CAD, and then he hears it from Cami Moya as soon as he gets on scene. And of course, Officer Esposito is able to witness the suspect, and he's able to hear the suspect yelling profanities. At 1 minute and 37 seconds in defense 2, Officer Esposito, still calm, still reasonable, says into his police radio that Travis Moya is standing in the driveway, balling up his fists. At 1 minute and 56 seconds, Officer Esposito tells Mr. Moya again, "We're here to help." And in response to that, Cami Moya tells Officer Esposito, "You can't reason with him." And it's clear that you can't. Around that time, about the 2-minute mark on Defense Exhibit 2, we have Officer Fruden arriving on scene. Officer Fruden also maintains a calm, respectful tone. He asks Travis Moya, "Hey man, what's going on?" And Travis Moya continues to yell at the officers, "Nobody called you." You can hear Officer Esposito tell Cami Moya around the 2-minute and 20-second mark that he wants to de-escalate the situation, but that that's not happening. In Defense 3, which was admitted, this is Officer Fruden's body-worn camera footage. You can see Travis Moya pointing at Officer Fruden and saying, "He's not dealing with this shit. I'm not dealing with this shit." He points again at Officer Fruden, he hunches over, and he makes 2 fists flexing. You can see this threatening posture captured in Defense 13. This corresponds with the 2-minute and 15-second mark in Defense 3. Defense 13 is a screenshot of Defense 3. Around 2 minutes and 18 seconds in Defense 3, you can hear Travis Moya yell to the officers, "I am not the one." And that's when he removes his jacket. So it's not a jacket taken off in isolation, it's a jacket being taken off. At the same time, he is making these threats to the officers. So recognizing these things, the removal of the jacket, the clenching of the fists, what he's saying, these all together as pre-attack indicators, which is what Officer Fruden and Officer Esposito testified to, as well as our experts. These pre-attack indicators, this prompts at that point Officer Fruden to put his hand on his taser. And in Defense 14, which is the audio-enhanced clip of Defense 3, you can hear that Travis Moya says, "You pull out your taser, I'm gonna tase your ass back. You pull out your taser, I'm gonna tase your ass back. And he says that threat twice. And Cami Moya is right there when he says it. She's on the other side of the vehicle that Travis Moya is standing beside. And she then, after he says it, raises her voice to Travis and says, babe, please, Travis, stop. At the 3-minute and 5-second mark in defense 3, you can hear Officer Esposito tell Mr. Moya not to go back in the home. We heard plenty of testimony about all of the concerns involved when someone like Travis Moya would go back into this home under these circumstances at this point. There's a weapon in the home. There are children in the home. But Travis Moya is not obeying commands. This is when Officer Fruden and Officer Esposito approach. And Officer Esposito, at this point, you can see he has canine Aries out of the vehicle, but at a distance from Travis Moya. And standing at a distance with the dog barking, Officer Esposito says, get on the ground. The presence of the dog, for most people, might have been enough to get on the ground and obey commands, but not for Travis Moya. You can see he looks right at Officer Esposito and the dog, and he does not get on the ground. The canine presence is not enough for compliance, clearly. So with Travis Moya at this juncture not following commands, Officer Fruden steps closer and he attempts to take Travis Moya's hands behind his back.
By this point, do we have other officers on the scene?
Almost at this exact second, the other two officers, Officer Benfield, Alpharetta Police, and Officer Melee from Milton Police, formerly Milton, now he's with Roswell, are approaching at this almost exact same time, simultaneously. So they're seeing this attempt to effectuate arrest. And in defense 3, at 3 minutes and 36 seconds, as Officer Fruden says, put your hands behind your back, Travis Moya says, no, 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 don't touch me. So you have Officer Melee, Officer Benfield, Officer Fruden, and Officer Esposito all trying to effectuate an arrest. Officer Fruden testified that he could not get the suspect's left hand behind his back, and that Officer Melee and Officer Benfield were trying to assist. Officer Fruden testified that he could see that his other two officers were struggling too, and that he realized that 3 officers did not seem to be enough at that point to get Travis Moya handcuffed. Officer Fruden testified that he knew that based on everything he had seen up to this point, based on what he felt with the suspect's body, that the suspect was not going to comply. He testified that he was tensing, that he was resisting. Officer Fruden testified, and this is very significant for this hearing, that he was really concerned at this point because the suspect had not been patted down.
So Fruden has all these feelings. How is that relevant? Because I don't think there's any evidence that Fruden was telepathically sharing with Esposito, hey, I'm nervous about this. Aren't we focused on what your client is thinking, as opposed to, not that it's unimportant what Fruden is thinking, but he didn't then deploy a taser, and now we're here figuring out if that was an unlawful use of force.
Certainly. Officer Fruden corroborates what Officer Esposito testified to, that he stood from a vantage point. And I do want to add one additional thing about Fruden's testimony in these split seconds, that he testified that at that moment, the individual who had the best vantage point as to what was happening was Officer Esposito. And Officer Esposito testified that what he was watching was exactly what Officer Fruden described. 3 officers attempting to handcuff a large suspect who had not obeyed a single command, and all 3 were struggling. Again, the suspect had said, no, 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 don't touch me. And both Officer Fruden and Officer Esposito testified that during this moment, these fractions of a second, is when Travis Moya turned with a fist away from officers. And you can see this in defense 17. That's a screenshot from Esposito's body-worn camera. And this is what Officer Esposito testified to as well. And it's in his report that he watched at this moment as the 3 officers failed to secure the suspect and saw a swing away from officers, and that the suspect, who had clenched fists before, had a clenched fist again. Officer Fruden had to do a leg sweep at that point, and the suspect still did not put his hands behind his back. As the officers, both Esposito and Fruden, had testified, the hope was that with the leg sweep, he's on the ground, he lies on his stomach, and he submits to the handcuffs. He does not do that. We see Travis Moya staying tense in a push-up position. And again, still at this point, with the suspect on the ground, Officer Esposito has the best vantage point as to what's going on. He sees that the suspect is refusing to put his hands behind his back. And all of the defense witnesses, I believe, testified to what a suspect in that push-up position tensing could do. He could kick, he could punch, he could grab a weapon from one of the officers near him. Officer Esposito explained in his testimony that the firearms are secured. There is a triple mechanism of some sort that prevents the suspect from being able to easily grab a gun, but that mechanism does not exist for any other weapon on all three of these officers' bodies. And so the thoughts that are going through Officer Esposito's mind are that not only can this suspect use his hands or his feet, but he could also potentially grab another weapon, handcuffs, OC spray, a taser, which he had threatened to do at that point. We also heard testimony that there was concerns that the suspect could potentially get to a vehicle or potentially get back into a home where there was a firearm. The door to the home was open, there were children inside, and the door was just a few feet away. Additionally, Officer Esposito testified that he had an experience that was very similar to this. And this went into his analysis. So he's looking not only at what's before him with this unruly, non-compliant suspect, but he testified that he was attempting to effectuate an arrest before this with a much smaller build female suspect who went into the push-up position, and she was able to kick him in the groin. So his perception of these circumstances was based not only on what he saw in front of him, but his experience as law enforcement and the fact that in this exact situation before, he had suffered injury trying to detain somebody who refused to put their hands behind their back and submit to handcuffs. And so it's at this moment that officers, including Officer Esposito, had every reason to believe that with Travis Moya in the push-up position, unlawful force was imminent. When Canine Aries was directed to bite, he did bite Travis Moya's jacket first, and that could have been an additional opportunity for Travis Moya to comply, to put his hands behind his back, but he doesn't. The canine bites, the bite was on an upper extremity, the arm. It was a bite reasonable in duration. There was nothing inappropriate about the nature of the bite, and that's according not just to defense expert Brad Smith, but to the state's expert, Ian Adams. You can hear officers saying over and over again during the bite, put your hands behind your back, put your hands behind your back. And still the suspect does not. But with the bite, Officer Fruden is able to grab Travis Moya's left arm. That's at 4 minutes, 13 seconds in defense 3, and pull it behind his back. So Travis Moya never willfully complies himself. He never puts his own hands behind his back. But with the bite, he is finally secured, and Officer Esposito rushes to quickly apply a tourniquet. And as a result of this, he's here today charged with aggravated battery, aggravated assault, and violation of oath of office. Law enforcement officers, like any citizen, can seek immunity from prosecution when they are indicted based on their use of force. Their burden remains the same as anybody else's. But because Mr. Esposito encountered Mr. Moya in his capacity as a law enforcement officer, it is relevant for the court to consider the legal classification of the encounter. So I will go briefly into that. In a second-tier encounter, an officer develops reasonable articulable suspicion that the citizen is committing or has committed a crime, and then has the authority to detain the citizen for an investigative stop. The suspect's physical resistance to this detention is unlawful, and the officer may take reasonable steps to protect his safety and the safety of others while detaining the individual. Here, officers had reasonable suspicion that Travis Moya had committed a crime almost immediately upon arriving on scene. They had some knowledge of the situation from the CAD notes, and then Moya's behavior corroborated the CAD notes. Moya failed to follow officer commands outside the home. Cami Moya told officers that he had thrown a chair and punched a wall. Moya threatened officers himself. All of this happens within a span of minutes. But the officers in this situation quickly developed more than reasonable suspicion, and they testified to this, both Officer Esposito and Officer Fruden, that they had probable cause to arrest Travis Moya. And so in a third tier encounter, an arrest, an officer has probable cause to believe that an individual is committing or has committed a crime. And the officer is authorized to make an arrest, and they're authorized to take that suspect into custody.
Is crime any crime? Does it have to be a felony, or it could be disorderly conduct?
It could be a misdemeanor.
Okay.
Officer Fruden testified that, this happens in a matter of seconds as this whole case seems to unfold. And initially he was arresting him for misdemeanor obstruction, but during that attempted arrest for misdemeanor obstruction, he realized that now he had probable cause to arrest for felony obstruction.
But I don't need to view this as a third tier encounter. You believe I don't need to find that the pulling away where the hand that was pulling away may have struck, I think it was Officer Fruden, intentionally, unintentionally. I don't need to resolve, was that an intentional strike of Officer Fruden? Because we've got disorderly conduct, misdemeanor obstruction, either of those, and there may be others, would have been a sufficient basis to make this a third tier encounter, in which case not only could they lawfully detain Mr. Moya, but they could actually arrest him.
That's correct. The same analysis works when any crime is being committed: misdemeanor crime, felony crime, state crime, federal crime. And here Officer Fruden provided credible, competent testimony that he believed that he had probable cause to arrest for a misdemeanor, which quickly became probable cause to arrest for a felony. But regardless, under this analysis, what's important is that Travis Moya was not authorized to pull away from the officers, which he did, because of the probable cause. At that point, any resistance to the arrest is unlawful. And as we know, there has already been a finding in federal district court that the officer's probable cause was sufficient. So then the next question under our analysis with the immunity statute is whether Travis Moya's conduct constituted an imminent use of unlawful force.
Tell me your legal basis for saying resistance to arrest is unlawful.
Because the officers on scene had probable cause to arrest Travis Moya and put him into handcuffs even before he swung. The fact that he said, no, don't touch me, is unlawful force. The fact that he doesn't submit to handcuffs is unlawful force. And when I wasn't asking what the examples were. Where do you get the proposition, other than you're saying it, that resisting arrest with force is unlawful force? Because under all of the cases, Copeland, and I have a few others that I'll cite for your honor, Larsheet is one that I'm going to rely heavily on. That's 367 Georgia App 660. When we do this analysis of what type of tier of citizen police encounter do we have, when you're dealing with the immunity statute with law enforcement, the reason that we look at that is because resisting arrest unlawfully can constitute unlawful force under the immunity statute. Okay. And those cases get into that. I'm not disagreeing with you. I'm exploring this with you. And I was just curious the origin of your assertion that forceful resistance to arrest is unlawful force, which could get you into the realm of justifying the officer using force to overcome that. Yes, Your Honor. And I imagine the state typically cites Copeland in these cases, State v. Copeland. It's a 2020 case, and it spends some time talking about why we go into the tiers of police citizen encounters. And Copeland is what citation? Let's see here. I have this is a Westlaw citation, 2020 WL 6. Okay, I'll get you it momentarily, Your Honor. But in this case, which is factually, I think, somewhat dissimilar from ours, but it does explain why we review the different tiers of police-citizen encounters and explains that if you have reasonable suspicion or probable cause to effectuate an arrest, then the resistance to that arrest is considered unlawful force under the immunity statute. And I'll get you the proper citation in a moment.
Okay.
So given that Mr. Moya's conduct was unlawful force, the question is whether Officer Esposito, in directing the bite, believed that more unlawful force was imminent in that moment and whether that was a reasonable belief. And we analyzed the force needed by law enforcement to reasonably defend against such force. And so here, unquestionably, it was reasonable, based on the facts and circumstances before him, for Officer Esposito to believe that force was necessary to defend his force.
Isn't the question we're working through, it's additional force is necessary and how much additional? There was already force being applied, that's really not the right word, to Mr. Moya to overcome his resistance to the arrest. That's the three officers. What your client concluded was that additional force was needed because 3-on-1 wasn't working out in a way that was safe for Mr. Moya, safe for the officers, potentially safe for people in the house, given the uncertainty of the situation and the way the officers were perceiving Mr. Moya to be acting, that he might, in a normal frame of mind, not wish any harm upon his wife or his kids, but this wasn't a normal frame of mind for him. I think everyone agrees with that. So really what we're looking at is not should force have been used against Mr. Moya, it's was the additional level of force that Aries brought to the equation reasonable? I mean, I think that's how I'm viewing it, because there was already a whole bunch of force. Got a big guy not giving his arms up in the tabletop position. The officers weren't so huge, but it was three officers trying to get the arms where they were entitled to get them, given, I'll hear from Mr. Watkins, but I think he has a particularly steep climb if he's going to say it was okay for Mr. Moya to resist. And I'll hear that out. But if it wasn't okay for him to resist, we need to work through what's the reasonable reaction to that. And that's where the experts disagree. And that's where I'm struggling, because there's not a nice set of step functions where it's three officers and now it's three officers plus OC spray. You couldn't use OC spray right there because everyone's head was in the same place. I can't really swing an ass baton because I might hit one that could be worse than a dog bite, but I also might hit my partner in the eye or who knows what. But so we had this big step function to a form of force, and I appreciate people saying it could be lethal. It wasn't lethal here. The dog didn't bite anyone in the neck, but it ramped things up exponentially from where they were. And that's what we need to work through. What I need to work through was that escalation. I don't mean that in a pejorative sense. Was it reasonable in light of the circumstances? Because there was already plenty of force being applied in opposite directions. Mr. Moya not giving his arms, three officers trying to get those arms. And your client concluded in his professional judgment that the appropriate additional force was Aries, and not Aries on the jacket, but Aries on the upper arm.
Right. And the analysis, Your Honor, I think the cases make clear that what we have to look at is, in the case of law enforcement, whether the force needed by Officer Esposito was the force that could reasonably defend against the unlawful imminent force. So there is kind of an added layer of the reasonableness analysis. Can the bite of Aries reasonably defend against the imminent use of unlawful force from the suspect? And here, certainly, it was.
I don't know that it's reasonably defend, because so would a shot to the head. That would reasonably defend, but I don't know that you would be up here arguing the right thing to do was to shoot Mr. Moya in the head. I don't think that would have been a real defensible action by Officer Esposito. And he didn't even contemplate it. No one got their gun out. So it's a question of whether that decision was reasonable in that situation and justified by the unlawful force already applied. And then to your point, I think it's a fair one, the reasonable expectation of continued unlawful force. the continued resistance. We don't know what's in the waistband, if there's anything in the waistband, et cetera.
Right. And again, a case that I'm going to rely on, State v. Larsheed, that's 367 Georgia Act 660, goes into this a bit. In that case, the state appealed a granting of an immunity motion and argued under Copeland, and here's your site for Copeland, 310 Georgia, 345 or 850 SE 2nd 736. And the state argued that the trial court had misapplied Copeland because it did not analyze the reasonableness of the belief of the officer regarding the severity of the suspect's force or the degree of force that the officer needed to reasonably defend against the suspect. And the court breaks down the immunity statute and basically says that an officer is entitled to immunity when the force is, and it basically just says, as you referenced, Your Honor, that we can look at whether the force was intended to be deadly force or was deadly force. But beyond that, all we see is whether it was reasonable for that individual in that circumstance to believe that unlawful force was imminent and therefore they acted in self-defense. And so I think to take it too far is a misreading of Copeland, and that's exactly what Larsheed stood for.
Okay.
And in this case, Officer Esposito had any reasonable person and had plenty of reasons to believe that a directed bite was necessary to defend these other officers and potentially the family from Travis Moya. We saw it in the body-worn camera, all of the moments that led up to that bite, and it was reasonable to believe that while in that push-up position, unlawful force was imminent. Travis Moya at that point had told officers that he was not the one, that he was going to tase their ass. They hadn't seen him be compliant. He was large, he was tensing, he was resisting, he swung away. He had not been patted down. There was a gun in the home. He could have easily punched or kicked one of the officers. And all of this potential force would have been considered unlawful.
How do I work through something that I've struggled a bit as I've been thinking about this, once Aries is out, Officer Esposito, meaning out of the vehicle, and the handler has Aries, Officer Esposito has foregone a less extreme use of force, which would be 3-on-1. I'm jumping in there too, and now it's 4-on-1. And so I'm gonna go for that left arm because Fruden's got a leg and Melee's doing this. But Officer Esposito can't do that because he'd have to ask Ms. Moya, hey, hold the dog. He's not going to do that. Ms. Moya is going to say, I'm not holding your dog. He'd have to go all the way back to the car, put Aries up, and that would be dereliction of duty. Hey, you three guys, just handle this. I'm going to come help you, but I've got to put the dog away. So did he get the dog out too soon? Almost like I've got my gun out. It's not aimed at you, but I've got my dangerous weapon out because I'm not sure what the situation is. And I'm not second guessing. I'm not the dog handler. I wasn't there, but it meant that what seemed to me as a Monday morning quarterback, your next step when your three partners, colleagues can't get Mr. Moya under control is you help him. And he did, but he helped them in a way that is an escalation of force than if he had gotten down there with them and said, look, we'll each get a limb. And that we could do. If we each get a limb, we'll make this work. But he couldn't do that because Aries was already out in a situation that until then, why was Aries even out of the car? So I just don't know how to unwind that because it's not an excessive use of force or it's not aggravated battery or aggravated assault. To have Aries out, it might have gotten Mr. Moya more concerned. We heard from Ms. Moya that she was, why is the dog already out? And the dog's not quiet. The dog is making itself known. Again, that's not use of force. That's a decision on how the law enforcement community is going to interact with the community. But it sets certain things in motion. That's the wrong way to put it, because I don't believe for a moment Officer Esposito said, I'm getting the dog out because I know I'm going to let it bite someone. What it did was preclude other options that maybe could have addressed the situation with a lower degree of force. And I don't know, so that's not going to be Copeland, that's not going to be Lashear, there's not going to be a case right on point, but I'd like you, and Mr. Watkins will get a chance to do that as well, help me think how that works, that it's almost like Officer Esposito unintentionally backed himself into having to use Aries. I'm not faulting him for that. I want to be real clear. But because Aries was out, the only way he's going to be able to help his guys is with Aries. He's not going to, with one hand, tase and hold Aries or anything like that. And so the die was sort of cast if things got a little bit out of control. Wouldn't expect they would 3-on-1. But here's someone who is big enough and under the influence of something enough that 3 are not able to fully control 1. And so we need plus something. And it's either plus Esposito jumping in there or it's Aries. And it was Aries, but Aries is a whole lot more than just Esposito.
I think the way that Your Honor just described what my client was doing, you referenced the use of Aries. And respectfully, the way that you described it, it sounds as though your interpretation of the use of Aries is only a bite. And how my client was trained as one of the few canine officers on the force and properly trained, and what Brad Smith testified to, and I believe Glenn Corbett as well testified to, is that the dog is not just to bite. And what we saw here was Officer Esposito bringing the dog out after Travis Moya had said, "I'll tase your ass back, I am not the one," and was attempting to use presence.
No, I understand. I hear you, and it's a fair point. I think the parallel is Fruden put his hand on his taser.
Mhm.
That message was clearly communicated,
Right.
because then Mr. Moya starts saying, "I'll tell you what's going to happen with that taser." And so simply having Aries out, we heard from Ms. Moya, that clearly communicated a message that Officer Esposito thought that this situation could get complicated, and here's a way to get folks to realize that it's serious and you're going to need to comply. So that's a fair point. It's just, unlike Fruden putting his hand on his taser, simply by going like that, his hands are now free to engage in a way that is a lesser use of force than tasing. But with Aries on, Aries out and deployed and being handled, if you will, by Officer Esposito, he's essentially monodimensional. It's not quite monodimensional because there's the presence, which was a loud presence, but it's just either the dog is barking or I'm deploying the dog. That's it. Whereas I'm tapping my taser. I don't even pull my taser out. Okay, man, you're serious. You took your taser out. Here are my hands.
Right.
And then ultimately, of course, you could deploy the taser as Aries was deployed. We're just missing a little more of the sliding scale. And again, this isn't a fault thing. That is the plight and the role of a canine officer, because you can't press a button and the dog hops into a holster. The dog is out, and until you get that dog back in the vehicle, you're kind of tied to that dimension.
And I think when we're looking at what a reasonable person would believe under these circumstances, I think any reasonable person would believe that with 3 officers trying to effectuate an arrest and with your dog, that the person is likely at that point going to put their hands behind their back. And that's why Officer Esposito behaved as he did. I don't think that he ever expected that, even though he knew it was escalating, and he said that in his radio, "Step it up, he's being disorderly, he's balling his fists." Nobody wanted this to happen. And the reality is that a reasonable person would believe that 3 officers and the presence of a dog is, when you've been calm and you've been patient with somebody, for them to put their hands behind their back. When you've said, "We just want to talk, we're just here to help." And when it was clear that that wasn't happening, using Aries was the right response to defend against this imminent use of unlawful force from Travis Moya. That's the reasonableness analysis, and that's exactly what was before Officer Esposito. I do think it's important, Your Honor has indicated a little bit about what you think in terms of whether the canine was intended or likely to cause death or great bodily harm. I do want to make a short record on that. Whether the use of any object or device constitutes force that is intended or likely to cause death is a case-by-case determination. And so even though we have the Robinette case, which says that canines, when properly trained and used against a felony suspect, are not considered lethal or deadly force, here also, when we do the case-by-case determination, that holds true. So we look at how the device was used, how many times, for what duration, and under what circumstances. And Officer Esposito himself testified that he had no intent to cause serious bodily harm or damage physically Travis Moya. He said that he intended to get him into compliance and handcuffs. And you heard Officer Esposito on the stand, and you see it in the video after the bite when he's talking to Cami Moya around the 9-minute mark. saying that he didn't want to use the canine, but when a suspect is non-compliant and threatening officers, he has to use the tools that he has. And Cami Moya says, I understand. And so part of what we're looking at is intent. That intent is very clear in the video and through my client's testimony, but also the canine bite itself. And both Brad Smith talked about the nature of the bite being appropriate in duration and location to comport with training and to not cause death. And we heard the state's expert essentially say the same thing.
So I want to explore the serious bodily injury piece a little bit because I don't think it's a particularly fruitful area for you unless there's a clear legal definition of serious bodily injury. I think the lay observer who is determining reasonableness of the situation is going to see how long the dog was latched on and shaking its head, the blood, and then sort of the pictures afterwards. And I haven't polled anyone, that's not my job, but my guess is that 9 out of 10 would say that's a serious, it's not a paper cut. But I don't know that you need to engage in that debate. And that's what I want to explore. Is it driven by what was the nature of the injury? What was you could use OC spray and a freak thing could happen. It gets in the guy's eye, he trips, he falls, he hits his head on the curb and he dies. OC spray is not lethal force. The outcome could be lethal, clearly not the intent of the officer. And I don't think there has been anything made in the record that suggests that Officer Esposito had lethal intentions when he deployed Aries. But I might conclude that the injury that Mr. Moya sustained was a serious bodily injury. Does that conclusion undercut in any way an assertion of immunity? No. Because if it doesn't, then you probably shouldn't focus a whole lot on was it serious or not. One, it's probably hurtful for Mr. Moya to hear, but two, it was a nasty wound. It really doesn't matter how you slice it. And I appreciate that your expert dog expert, like, oh, I've seen worse wounds than that. Well, so have we all if you've watched a murder trial. I've seen people with most of their head missing. And then we're grateful that Mr. Moya is alive and well enough, but that was an awful injury. I wouldn't want that to happen to anyone I know, but it may have been a necessary outcome. Necessary is the wrong word, but the outcome of his unlawful use of force in this situation.
Right, and this is why I want to make the record, Your Honor. Our position is that it was not intended, nor was it the type of tool or device to cause serious bodily injury or lethal force. However, and this is again where Larsheed comes in, Larsheed's pretty on point for this. There we had a judge that kind of made an alternative finding given the facts of that case where you had a suspect that committed felony obstruction. It was a female, smaller, on the ground, refused to get on her stomach and put her hands behind her back. That was an Esposito case. And what the court found was that, first of all, the Esposito as used, it was 30 strikes, did not... 3-0? 3-0. And very similar facts in terms of the suspect being on the ground when the strikes in question were administered. And what the court did was kind of have a finding and then an alternative finding, both of which fit the facts. And I think that that's appropriate here. And that's basically that, no, the Esposito as used, as intended, based on the officer's testimony and the testimony of the experts, doesn't rise to that level of lethal force or serious bodily injury. However, even if it had, that the suspect had engaged in a forcible felony obstruction under OCGA 161024B, same facts here. And a person is justified in using force, which is intended or likely to cause death or great bodily harm to prevent the commission of a forcible felony. And so here, as in that case, I think there can be an alternative finding. I don't want to spend too much time on that. I wholeheartedly agree with everything you said about the fact that nobody wanted anyone to be injured, at all in this situation. But I do think it's important for the record to explain that under either finding we win.
Okay.
And in Larsheed, the court also engaged in some credibility determinations, and I do want to briefly make a record on that. There, the court found that the suspect who did testify was not credible because the version of the events did not match the video evidence. And obviously we don't have the suspect testifying here, Your Honor, but I do want to say that when it comes to Ms. Moya's testimony, she said her husband never threatened anybody and that he never threatened to tase anyone because he doesn't even have a taser. And so that is inconsistent with what the record shows, what the body-worn camera footage shows. But our witnesses, Officer Esposito, Officer Fruden, Glenn Corbett, Brad Smith, they were credible, they were consistent. I do want to speak briefly about the state's expert. He did testify that when he had previously testified under oath at grand jury, for whatever reason, he had never looked at the CAD, he had no idea a gun was in the home, and testified at grand jury.
Well, this is all true, and that was interesting testimony. The way he explained the acceptability of that in still offering an expert opinion was that he put great weight, almost exclusive weight, on the fact that Officer Esposito said, hey, up until this point, everything's good. And so the state's expert's focus was what changed from that point onward. And he and I engaged in that a little bit. Like, well, how can you ignore what Officer Esposito already knew from the CAD, from the call, from Ms. Moya, et cetera? Those are all things that factor in. And he pushed back and said, sure, he knew those things. There's always risk. There's always risk. There's a threat of this or that. But per Officer Esposito's own words, up until the pulling away, he wasn't even thinking about deploying Aries. And so his analysis was what happened. And now we're talking about like 2 seconds. There just wasn't a lot of time, as opposed to your review, which I think is a more compelling review, but I want to understand your rebuttal to it. You start from the moment Officer Esposito gets the call, he's beginning to absorb information. And frankly, he brings in prior information, the encounter with the woman in a push-up position. These are all facts and circumstances that officers are entitled to rely on when they confront a new situation. No two situations are identical, but if you don't learn from your past mistakes, you got to get out of that line of business. But fact remains, Officer Esposito said, hey, up at this point, Aries and I, we're where we need to be, and there's no engagement. And so why isn't it the correct thing to just look at what happened after that? And what the expert really ended up saying is the really only risk was risk of delay. Moya wasn't going anywhere. Those three guys had him. They were going to struggle a little bit more. And so it was sort of a war of attrition. And why did you escalate? There isn't a clearly articulable concern, risk, threat, other than that threat or risk of delay.
Right.
Respond to that, because you don't get to when you question him. Now you get to, you can say, here's why that's nonsense, or, well, it's a good point. I don't have an answer.
Right. Well, it's what we do all the time under the reasonableness standard. We think about what a reasonable person would do under those circumstances. The phrase circumstances means the facts and circumstances before the reasonable person in that scenario. And we don't look at 2 seconds in a vacuum. We look at these circumstances and what a reasonable person would do within those. And what I thought was really telling with Officer Adams, who also spent some time talking about intrusiveness, which I don't think is relevant and a red herring, is that, I cross-examined him on his use of a canine with a suspect who either had one hand or both hands in the air, and the canine bit the suspect on the face with either one or both hands in the air. And what Dr. Adams countered with that was that, well, I knew 2 weeks ago he had been arrested and he had been making bombs, and he had all of these things that he pointed to, many of which happened weeks in advance. That was his explanation for why, in that point, his use of a canine to bite a face of a man who had his hands in the air was reasonable. And so his own testimony contradicted himself. What we look at under the reasonableness analysis is the circumstances. And here we consider the circumstances known by my client, which starts with the CAD notes, all of the corroboration he saw on the scene, and everything else that happened and unfolded in a span of mere minutes before the bite. I do also want to highlight, for your honor, when it comes to some of the weighing of credibilities and the experts' opinions, that obviously Dr. Adams has never testified in Georgia before this case. And
why did that matter? You brought that up. And I mean, the concept of reasonableness is hopefully fairly universal. What's reasonable in Montana ought to be kind of reasonable in Georgia. And there may be slight cultural differences, but I was not unimpressed that he hadn't testified in Georgia. He's from Utah, and so he hadn't been to Georgia before.
Right. And I think the reason I just want to highlight that briefly for Your Honor, it's obviously not like the crux of our argument, is because the immunity statute contemplates some of the criticism that he had in terms of the Alpharetta policy. So you have this out-of-state expert talking about the fact that I don't like how resistance is described in this policy, but we see under 16.3.21 subsection C that any policy of any agency of the state that's in conflict with this code section is null, void, no force or effect. And so I think we don't have to care whether an expert criticizes Alpharetta's definition of resistance. That's not what's before the court. And I just wanted to point that out for Your Honor because it's applicable in the statute that's before us today. And of course, you heard that Glenn Corbett, who testified about training and the tiers for us, also noted that he was consulted by ADA Sue Chan and said, no, I've reviewed everything and I believe I can't testify for you because Officer Esposito acted lawfully. And then they have Ian Adams. And so again, with Ian Adams' analysis, the reason that it's incorrect is that it doesn't take into consideration circumstances, which is exactly what we need to do in determining the reasonableness of Officer Esposito's behavior. He basically said that it was just the moments after or right around the foot sweep that Officer Fruden did. But the reality is that Officer Esposito, a trained officer, arriving on scene and seeing a suspect threatening and being non-compliant is allowed and should have taken all of those into consideration, all of those things into consideration before making the decision that he did. These reasonable beliefs do not happen, as I said, in a vacuum. The state also spent some time talking about risk versus threat, which I don't believe has any basis in our legal analysis whatsoever. Travis Moya threatened force, and that's what the statute contemplates. If there's a risk of force, if there's threatened force, I mean, I don't even think we have to talk about a risk because we had actual literal threats, including I'm going to tase your ass. But I do want to make sure that we're on the same page in terms of whether just the threat is enough, and it is. We don't need actual force here to find Michael Esposito immune from prosecution, because even if that swinging, that fist that has been described as swinging away, that conduct which District Judge Ross found rose to the level of felony obstruction, even if that is not a punch, even if that the way that it hit Officer Benfield's face is not an actual punch, it doesn't matter. And this is clear in State versus Green, 289, Georgia 802. This is a non-law enforcement case, but it contemplates just the threat and why a threat of imminent force is enough. You don't need to have actual force to find somebody immune from prosecution when they react to the threat, to the risk, whatever you call it. It was there and it was very, very real. The other thing that the state has spent some time talking about is whether this was simply like a mental health situation and whether anybody had asked for police to be there. But there's nothing in the statute that distinguishes a mental health situation from any other type of police encounter. Certainly, we heard the 911 call, and it sounded as though at the time, the son said, I'm sick of this shit, and I do want the police here. And yes, Cami Moya testified that she wanted an ambulance, and we hear her say that on the phone, but that does not matter, because the reality is that whether what we see before us on the body cam footage, whether this is the result of a mental health crisis, whether it's the result of Travis Moya being on PCP, whether it's the result of him just being angry, it doesn't matter. The analysis is the same. It has to do with whether there was the imminent use of unlawful force against officers and potentially others. And that is what Officer Esposito was responding to when he directed Aries to bite. I do just want to say, Your Honor, that you heard from Officer Esposito about why he became an officer. And he did it to, he thought he could contribute to society. You know, he was Officer of the year that this happened. He earned a Medal of Valor. You can hear from his tone in the video when he first arrives on scene, and then even after the bite, there's this softness, there's this kindness, there's this constant assertion that I was just trying to help. And he did take this oath to protect lives and property, to prevent and detect crime, maintain order, and apprehend those preying upon the unsuspecting, and to safeguard the constitutional liberties of all. And he did that here. He's been joined in the courtroom 3 times now from his family, many of whom live out of state and have flown in every single hearing. And at this point, Your Honor, based on what we've shown through, again, competent, credible evidence and testimony, and given the law of Georgia, 16.324.2 and 16.321, this is the juncture where this case legally is prevented from going forward. My client broke no laws. He acted in self-defense. He directed his canine to bite as he was trained to do in a moment where he believed reasonably and wholeheartedly that imminent use of unlawful force was about to happen against his fellow officers, potentially these children in the home, potentially who knows what else, but he didn't break any laws. And that's why we're asking that you make the only finding that is consistent with what's been admitted and what the law says, and that's that Michael Esposito is immune from prosecution and that all charges must be dismissed.
Thank you, Ms. Palmer. Ms. Rivers, are you good if we pivot to Mr. Watkins now?
Yes, Judge, I'm ready.
Great. Mr. Watkins, when you're ready, sir. And good morning.
Good morning, Your Honor.
Brian, you want to go ahead and share screen, or go ahead and share screen?
Your Honor, ADA Sue Chan will be assisting me with, I think, pertinent parts of testimony.
Okay.
So hopefully our technology.
So far, so good. I see it on the screen. Oh.
Judge, let me begin with the immunity statute here. And that 16.324.2 requires the court to find as a matter of law that the person was acting reasonably in defense of himself and or others. And State v. Copeland, as well as prior case law, directs that the defendant bears the burden of proof based on the preponderance of the evidence, and the court must not conflate the principles of reasonable use of force by law enforcement with self-defense and immunity. Again, that's from State v. Copeland, 310, Georgia, 345. That's a 2020 case. So let's bring this where it should be. And that is a 16.321 defense. So that when the defendant refers to Robinette or other federal cases, those are Fourth Amendment cases dealing with reasonable officers and not the reasonable person standard. And I'll ask the court to be careful with that, because if the legislature wanted this court to make decisions based on a reasonable officer standard, it would have incorporated 17.420 or 16.320 into this particular statute.
So I hear you, and it's an important caution that Copeland gives and that you are repeating. Isn't the same core concept, though, the reasonableness of the use of force at play with the immunity statute? It's not reasonable use of force by an officer. It's, was it reasonable in defense of self or others? You're right. There's not an immunity provision that says, oh, but if it's an officer, you need to look at it through a different lens. And I think that's what Copeland tells us and what you're sharing with me. But Copeland doesn't say for an officer, there's a different standard under immunity. Immunity, the self-defense provisions, which would yield you immunity, I have to decide, was it reasonable to use the force that was used in defense of self or others. And primarily this is defense of others. I didn't hear Esposito saying so much, I was worried about me. Heck, I got Aries right in front of me, but I'm worried about my colleagues. I'm worried about the people in the house. What if Mr. Moya gets in his car and zooms off in this state? What might happen to other people? He might hit someone in the car, intentionally or not. But the touchstone is still reasonableness. Was it reasonable for Esposito? I won't even put the word officer in front of him. Was it reasonable for him to use the force that he did based on his perception, and were those perceptions reasonable, of the threat that was posed, the risk of harm to those he was trying to protect? That's what self-defense is all about. Set aside the law enforcement piece. Let's say that Esposito walks out of a bar and there are three guys who've jumped on one guy. That's not right. I'm gonna get in this mix. I'm gonna defend that one guy. That's flipping this one around, but I'm gonna help defend this one guy. 3-on-1, I got a baseball bat. I'm gonna hit these guys with a baseball bat. The assessment of whether he should be immune from prosecution for aggravated assault by whacking those three guys with a baseball bat would be the reasonableness of his assessment that someone was at risk and the reasonableness of the force that he used against those three guys. So reasonableness is still at play. It's just not through the lens of should an officer do X at this time? Because that's when you're suing an officer for excessive force. And that's not what this litigation is about. Am I right, or did I miss your point?
No, I think, no, I understand what I think I understand what you're saying, that if three officers are trying to take hold of someone and a reasonable person acting in the capacity of not an officer, what would that person do with the dog that they have at the time?
Right.
Okay. Well, initially 7 seconds when a person's in a push-up position is not, a reasonable person is not going to deploy the dog when there are three other officers on him, especially if that person knows that one of the officers just taken the man to the ground. And again, the man is there and no more than 7 seconds have passed. And this individual has not made any other movement other than to pull his arms back to himself. He hasn't swung at the officers. He hasn't kicked them. So, but I'll get to that.
Okay.
Okay. All right. So I'll ask the court to try to remember State v. Copeland and not conflate the standards and mix the two. And the court was right on point to ask the question, as I laid out here in this second slide, the 16-321 defense, but we'll go to the next slide and let's narrow that down. Because if we look at this as the law is applied to this particular case, we can highlight where it says here that one can only use the degree of force reasonably believed necessary to defend oneself or others. Again, from the standpoint of a reasonable person. And such force may only be used to stop imminent unlawful force. So at the time that the dog is deployed, there is no offensive force being exercised against the officers.
So I don't know that that second box is one that it helps you a whole lot. I mean, I think it's accurate, but I think it's tough to say that Mr. Moya hadn't been resisting arrest and wasn't continuing to resist arrest. Force can be active, I push you away. Force can be passive, I pull away. Now, I'll hear you out on all this stuff, but I'm just giving you my thinking about this. Sure. I think your more powerful argument is the degree and scope of Officer Esposito's reaction to what he perceived was excessive, as opposed to there wasn't any justification. I don't think you would be prosecuting Officer Esposito if what he had done was jump into that fracas and begin striking with his hands Mr. Moya so that they could get Mr. Moya's hands. I would be very surprised if the district attorney's office brought a case against Esposito if he had gone in with hands and feet like his three colleagues.
I think you're correct. And
so, but he would have been using that force, I think, under setting aside whether it was reasonable use of force by an officer. in defense of his three colleagues. I don't know what's going on with these guys. This guy won't give them his hands. They could get hurt in this melee. I don't know if he's got something in his car or his waistband. So I think that there is some unlawful force going on here, and I'm just going to defend my colleagues and protect them and get in the mix. And if he had used hands and feet to do that, then that's sort of matching force with force, because that's all Mr. Moya is doing. I'm not saying he's hitting or kicking, but he's using his body and body only to passively resist, to use force. And currently, the three who are on him are using body only. The escalation, which I think triggers your prosecution, is what we ought to focus on, is bringing Aries into the mix.
Well, I think what Your Honor is suggesting is that if under the 16-321 reasonable person defense, whether or not the average layperson, Joe Blow, could have jumped in this and used his hands, and whether or not he would at that point be considered as not defending the other officer.
Right. What I'm saying is, I think that someone engaging with Mr. Moya in a forceful way, not just yelling at him, but putting hands on, pushing him, whatever, they would have been able to check box number 2, because there was imminent unlawful force. I think there was current unlawful force, because Mr. Moya was using force to not comply with a lawful arrest.
Well, I think the issue.
And if I'm wrong on that, you should tell me, because I want to focus on the areas
Sure.
where we really need to wrestle with it. I just don't think you get a lot of traction in saying, wait a minute. Another reason why Esposito was in error here is that there was no imminent unlawful force. And that gets to the doctor's threat versus risk and this and that. I mean, he was forcibly resisting arrest. I don't know how you describe it any other way than that.
It has to be force offensively used against someone.
Does it?
Well, this is
What if you are lying on your hands? I can't see what's in your waistband. You're lying on your hands and you won't give. I just saw you rob a bank. Forget it. I didn't see a guy. You ran out of a store. You just shoplifted. You ran out of the store with stuff you didn't pay for. Hey, come here. And you're lying on the ground with your hands underneath you. You're saying that that refuse, and I'm pulling at your arm and he won't give you, you're saying that that's not the unlawful use of force, that I'd actually, as the defendant, have to be swinging at the officer for it to justify me using more force to make sure nothing bad is going to happen there?
I think you're saying officer. And that's the key point I'm talking about. Officer performing his duties.
Okay, I'm doing exactly what you said I shouldn't, which is bleeding over, hey, an officer doing his job.
Right.
It's complicated.
It's complicated.
Okay,
But
fair point.
again, that's why we have to have this bright line rules, because this is what the legislature said. And we have to abide by that, because what the court is making a finding is, as a matter of law, that a jury shouldn't hear this. When he still has these defenses at trial. And guess what? We have an even higher burden of proof, because then we have to prove guilt beyond a reasonable doubt under 17-420, under 16-320. We have a higher hill to climb there. So it's that when such force is necessary to defend, that's what I'm addressing, Your Honor. Now, in regards to the canine that was used, it doesn't have to be his intention to cause serious harm. What the statute also says, the third point on the prior slide, is where the force used is likely to cause great bodily harm.
Is felony obstruction a forcible felony?
Felony obstruction is a forcible felony, but there was no felony obstruction.
You have to say that. I understand, but I just want to, because if felony obstruction is not a forcible felony, there's even more traction here for you. But I understand your argument that there may have been misdemeanor obstruction, but there wasn't felony obstruction.
And I think the evidence sufficiently shows there is no factual basis here to believe that Mr. Moya, as he's in that prone position, was that anyone could hold a reasonable belief of receiving a great bodily harm or to prevent the commission of a forcible felony. So with that being said, in reference to, I'm gonna go ahead and check this off right away so we can get to the meat of it, Your Honor. The federal court order, again, is a Fourth Amendment standard under Graham v. Connor. I asked the court to set that aside. That is not the issue here. And that what opposing counsel did during the bulk of our argument is precisely what the SOPs say, and I'll get to those also, as well as the law through Glenn Corbett says you can't do, and that is Monday morning quarterback. So the court is not permitted to take into consideration that Benfield may have gotten hit in the face if it wasn't observed by Officer Esposito, and he took that into consideration. The court cannot take into consideration that Fruden pulled out his taser, which he put back in, he reholstered, if Esposito is not making the same observations. In fact, what we see is at the very beginning, not shortly after the arrival of Esposito, is that Ms. Moya requested an ambulance, and that what Esposito did either before, immediately before or afterward, is his anticipation that he's going to use physical force because he put his gloves on. We'll get to that also. And as far as the defendant's reliance upon Larsheed, let me move that out of the way right away. And let's let the court know the very distinguishing factors in Larsheed, which is 367 Georgia Appellate 660, the 2023 case, is that McCrary, that is the person who was struck by Larsheed in that case, she reached toward Larsheed's chest, grabbed the front of his vest, and that the officer concluded these actions constituted unlawful force by McCrary. Further, that's after she was taken to the ground. He says eventually Larsheed forced McCrary onto her stomach and used his body weight to control her. Undeterred, McCrary grabbed Larsheed's baton. Larsheed attempted to pull the baton away from her and warned her, "Let it go or I'll shoot." So these facts are greatly distinguishable, and there are even more facts. I'm just reading a few of those, on how Larsheed is not applicable in this case. Let's talk about the experts. To begin, first, Mr. Brad Smith and Glenn Corbett, they were called very early on. So their opinions in this matter are not even based on the entire or most of the record. Their opinions are based on unsworn testimony, or I have sworn there. It's not based on sworn testimony. And that their expert opinions fail to consider the intrusiveness force of the canine. Now, they seem, well, at least Glenn Corbett did, because I didn't really question Brad Smith on this. And the intrusiveness of the seizure, as I put here, Tennessee v. Garner. This is the case that preceded Graham Connor. Now, in the facts of Tennessee Garner's, an individual had committed a burglary and was running toward a fence or whatever, trying to climb it, and he got shot in the back. And the court says the intrusiveness of a seizure by means of deadly force is unmatched.
So I want to pause you for a second.
Sure.
Aren't these cases all about Fourth Amendment and officer excessive?
Precisely.
Okay, so
Absolutely.
How do these bear weight on? I mean, you've told me, I think correctly, it's important to be aware of these principles, but we really are in a scenario where it would be in some ways more helpful to refer to Mr. Fruden and Mr. Esposito, because it's not an officer thing. It is, to get immunity, it's not, I did the right thing as an officer. I did the right thing as a reasonable person in trying to protect these others from the risk of great bodily harm or death, if it's that far along, or at least the unlawful use of force, something like that.
Sure.
So how do these cases apply to that? Or it's just your way of undercutting or challenging the weight or impact of the defense experts' testimony?
Correct, absolutely. It is to challenge the weight of their testimony to the extent the court believes it has to consider it. So out of abundance of caution, lawyers do what lawyers do. And that I'm addressing the fact that these, to the extent the court wants to give some weight, there's even less to the expert. There should be even less weight given to them because they don't consider the physical intrusiveness of the canine bite when Graham v. Connor says specifically that the Fourth Amendment addresses this sort of physically intrusive governmental conduct. Now, in that particular case, Graham v. O'Connor, that's where the young man was having some type of diabetic breakdown, maybe going into a diabetic coma. So he kind of started acting crazy outside of a convenience store, and the officers pulled up on him, were trying to subdue him. And his friends were telling the officers, he's having a diabetic coma, but they still physically restrain the individual nonetheless. So the court does look at physical intrusiveness, and what that does, this particular intrusiveness was not even considered by Brad Smith. Furthermore, to give even less weight to his testimony is that he did not consider 16.321 at all. He considered Graham v. O'Connor and 16.10.24b, and we'll go to that particular portion of the testimony as I have that presented here.
Smith, when you state that this was to defend the officers against the conduct of Mr. Moya, can you tell us if you were looking at the Graham factors in that regard?
Oh, yes, as far as for the use of force, absolutely I was, yes.
When it comes to defending the officers against Mr. Moya's use of force, were you looking at Georgia statutes in that regard?
I know you have one statute that, in regards to resisting arrest and things like that, but I used the Graham factors because that's what all use of force is based on, dogs, any type of use of force you want to use. So I was referring to that as well, whether it's defending, protecting, whatever words you want to use.
Georgia statutes, did you take into consideration in forming your opinions?
Yes, the Georgia statute of 16.10.24b with regards to the willful resistance, obstruction, opposes law enforcement, that section. That's what he was arrested for. That's what the crime that he committed in front of the officers, and then the force that was used based off the Graham.
And the statutes.
Objection asked and answered, Your Honor.
Well, he said, go ahead and answer the question. He's repeated this one, but I'm curious to know if there were any others either.
I don't like how my voice sounds. You almost done?
Correct?
No, just the one that I just did, 16.10.24b and Graham versus Connor, which is heavily covered in my report.
So his consideration of the facts and his opinion do not even consider only the reasonable officer standard. And that is contrary to Georgia law when looking at a defense of self or others at 350, referencing here State v. Jenkins at 355 Georgia Appellate 39 at 2020 case that says a justification defense is assessed on whether the circumstances would have excited the fears of an objective, reasonable person to the point where the use of force was justified.
Let me seize on that. I agree with that. I think that's obviously the Court of Appeals said it, so it's got to be a correct statement of law. So we'll follow that one. Circumstances. Your expert was persistent and consistent in saying it is the circumstances only after that point where Officer Esposito said, you know, up till now, I didn't think it was appropriate or justified or necessary to deploy Aries. But once, and I think it was, and the record will speak for itself, so don't panic if I'm saying the wrong instant. It was when Benfield maybe got struck in the face intentionally or not, or appeared to be struck in the face when Mr. Moya pulled away. That was when then Officer Esposito said, things are getting out of control and Aries may be going in. Wherever the point was, your expert was very clear. Anything that happened before then, you ought not to be thinking about, because Officer Esposito said before then, I didn't think it was justified to use that force to defend. And again, probably we were sloppy. Was it a proper use of force by an officer? Because I think all the experts spoke in that framework, and you're pulling us to where we need to be. And I'm going to physically move there, which is it justified under the self-defense statute and defense of others statute? But your expert nonetheless said, don't think about those other things. That's not what I think Jenkins says and what the case law would say. It would be the totality of the circumstances. And so if we take it out of a police officer experience, I think it's the Green case, but there's a case where people knew this guy kept a gun in a drawer and he's getting angry and he's going to the drawer. And so he gets shot. And like, you know what, because this person knew there was a gun in the drawer, it was reasonable to take action before that guy could get the gun out of the drawer. But it was the whole set of circumstances to include things that were known days or weeks before in considering whether it was reasonable for this person to use that level of force to defend himself or to defend others. So I said it in a whole lot of words, but do you step back from Dr. Adams's testimony that really the only thing we should be considering is the few seconds that went on from the point where Benfield may have been struck inadvertently or not in the face?
I think we look at Esposito's own words. And if he was that concerned about the location of a gun, if there was that great a concern as a location of a gun and the violent, what they now assert are the violent propensities of Mr. Moya prior to him, this contested issue, turning, swinging, whatever, then we would have had him asking Ms. Moya about the location of the gun when he arrived. Now, my recollection is he never asked her about that.
Well, it's in the house and Mr. Moya is not in the house. So we're already in a better space. It's not that Esposito is in the house with Mr. Moya acting the way he was acting and Officer Esposito not knowing, is it in that drawer? Is it there? He knows Moya outside, gun inside. And we do see from the footage when Mr. Moya starts working his way towards the door, everyone starts getting a little more concerned. Safety of the kids inside, ability to access the gun inside, all consistent with Esposito processing not just the 2 split seconds that your expert said we should focus on, but the entirety of what he had come to know or understand about the situation, from dispatch to interacting with Ms. Moya, et cetera. I think that's what I ought to be weighing as well. Your expert said no. And if you are siding with him, I need you to then unpackage that so that the language from Jenkins, when we're talking about the circumstances, is somehow so narrow to it's just that split second before you use the force. And it would be inappropriate for the decision maker, which right now is me, ultimately potentially a jury, to be thinking about these other data points, because you say we should rely on what Officer Esposito said. He talked about all those data points as to how he's gradually, now my word, not his, getting spooled up. Like, woo, this is getting hairier and hairier. Speed up. Get here sooner. This is getting complicated. I'm gonna go get the dog. I may deploy the dog. He's ratcheting up because he is seeing things. He is perceiving things that are making this more than simply, there's Mr. Moya, hey, could you come talk to me? That never happened because Mr. Moya never afforded him that opportunity. Mr. Moya is free to stay right where he is. It's his property. As Ms. Moya made very clear, these officers are encroaching in their space. They bring a dog. What's going on? And maybe answers aren't being given, but all of this is being processed by Esposito, so that when he finally says, go in there, Aries, all those things are flowing into it. He said as much in his sworn testimony. Your expert comes in and says, it's not fair, or fair may not be the right word. It's not appropriate to think about all those other things. It's just that little window. Your expert, not mine. How do I reconcile that?
Sure. I think the point you said was, I think the issue here is, whereas a lot of witnesses, as time goes by, facts fade. Mr. Esposito, as time goes by, we get more facts. And this is what Dr. Adams was talking about. If we look at his written reports, which will affect, look at his written reports, whether that be the deployment report, or we look at his incident report, there's no mention of concern for a gun. There's no mention that he is a potential threat to the family. He doesn't initially, they try to stop him from going in the house, true. But Ms. Moya is still the intermediary going back and forth, as well as another relative. When he has standing right there between two cars. So I understand the initial CAD report, the initial 911 is the statement that one of the children says there's a gun in the house, and then they come up and say, oh, he can have a gun on his person. Well, wait a minute, what are we going to rely upon?
I didn't say gun on person when you and I were discussing.
Correct. You didn't say it, but one of the officers testified, or he could have a gun on his. They didn't search. I think it was Mr. Smith. They didn't search his body. He could have had a gun on his person. Well, what are we going to rely upon? And quite frankly, the deployment report was created about a week after the incident, because it's dated August 2nd, 2021. And the incident report is dated the next day. So the SOPs state, and I'll ask Ms. Chan, I think I have it referenced in here. To turn to that page, I'll show you.
We're gonna have to jump forward. Okay.
What the SOPs say.
Looking for it.
Did you believe when you reviewed all the footage?
You can stop that. In short, what the SOP says is that you cannot consider after acquired information to make a determination as to whether the deployment of the use of force was appropriate. Not only do the SOPs say that, but Glenn Corbett said the same thing. And the SOPs further that were introduced, I believe is Defense Exhibit number 10, require that then when these reports are prepared, that all pertinent facts be put in there that the officer was relying upon at the time that force was deployed.
Okay, and I hear you. I also have watched you and many of your colleagues in court, because the roles are switched here, say to the officer, I know you try to be thorough, but in fact, you don't write everything down. I actually don't write everything down. I'm not perfect. I write down. Oh, but you write down the important things like gun. Well, yeah, I would, but I'm telling you there was a gun. Okay. And you argue to the jury or the fact finder. A report is a snapshot and not everything gets in it. But boy, those body cams, they show you what happened at the scene at the time. But all of a sudden now that's not good for the state. It's like, oh, if it's not in the report, it must not have happened.
Well, I guess what I'm suggesting to the court, this is a standard that is set down by officers. Okay. And they understand the importance that when it is a use of force matter, it is potentially other ramifications associated with that, including the fact that they may lose their job.
Okay. And so you're going to be extra thorough.
That is my understanding, and that's what the testimony was.
Okay.
Okay.
Yeah.
Yeah, so I have that listed here on the Defense Exhibit 10. Justification for the use of force is limited to what reasonably appears to be the facts and circumstances known or perceived by the officer at the time. Facts unknown to the officer, no matter how compelling, cannot be considered later in determining whether the action was justified.
Okay, but now we're talking about use of force with the police policy. I mean, you're back into the space Copeland says we're not supposed to be in.
I agree, but it still forms, I use force. In other words, his basis for a 16-3-21 defense, the facts are the same. The standard and the law is different, but the facts are not going to change. So in regards to Glenn Corbett, and I'll try to move along quickly on that. I think we may, Glenn Corbett stated that he did not consider 16-3-21. Now, if the court wants me to play that, I'll do it. Otherwise, I'll move on.
You can move on.
Okay. He said, instead, what he said was he relied upon 16-3-20, and 16-3-20 addresses government officers as well as employees fulfilling their duties. Further, and I've addressed this, the defense experts' opinions all deal with the reasonable use of force to detain or arrest. That is what they testified to. In fact, they testified that they weren't even considering 16-3-21. So let me move on to what Mr. Corbett said as it pertains to the issues of what his findings were, one of which was his opinion or what he saw. Now, granted, Your Honor, the body-worn camera doesn't show everything. We certainly accept that. But what Mr. Corbett testified to is that Mr. Moyer offered, from what he could see, he offered no violence. And this part of the video that we're going to have referenced here that Glenn Corbett was testifying to, I think that is correct. So I ask that that portion of the testimony of Mr. Corbett be played.
Is this the correct video?
Yes, he's in the upper right-hand corner.
Okay.
Because I was on that environment. You're being called to offer an opinion on the appropriateness on the use of level of the use of force, correct? Right. And to do that, you have to take into consideration the conduct of the target. Is that right? Yes. I'm asking you to take into consideration the conduct of the target and rendering an opinion as to whether or not he was offering violence.
Asked and answered, Your Honor, asked and answered.
Overruled.
He's offering resistance, but not violence. That's still unlawful force. Okay. Resistance is unlawful force.
Okay.
That's it.
So again, he was not offering, he was offering resistance.
Which he said is unlawful force.
Oh, yeah.
Okay.
Yeah. He says unlawful force in the context of an officer's duties.
Okay.
Okay. That he offered no violence, but he resisted. I mean, I guess the only way to resist an officer trying to pull your arms apart is to tense up, and you have to use some type of force to do that. The next question was that Corbett said that Moyer's conduct was not, he did not see any felonious conduct of Moyer. That's fine.
Yeah. It was just plain.
And Mr. Moyer, did Mr. Moyer engage in any conduct sufficient to rise to the level of a felony based on what you saw?
Again, from my viewpoint on the camera, I cannot tell. I have to go by the officer's statements.
Just based on what you saw?
By what I saw, no, I cannot say.
No further questions.
So I'll move on from Corbett because Corbett wanted to discuss about the deadly, that the use of force is to be put in just two boxes. It's not a sliding scale where the intrusiveness is either binary or is binary, is either deadly force or non-deadly force.
Did Mr. Moya engage?
And again, we've presented the law on that. It says that's not correct. You have to look at the level of intrusiveness.
Can you play that, Brian?
No,
Okay.
I'll move on from that. If the court wants me to play that, I will.
Nope, but moving on is great.
All right.
Thank you.
So that brings me to what the state's expert, Dr. Ian Adams, said. And what he said was that canines, use of a canine is one level below deadly force. It is not binary. You have to, and it only makes sense that you take that into consideration. The level of force, the intrusiveness of the force that is used.
How do you work through, I'll start with the gun example. Gun is clearly deadly force if used in the way it's designed, but you could also pistol whip someone. And so if the way in which, we'll go back to the scenario, you see three guys who've jumped on one guy outside a bar, you're lawfully carrying a firearm, you come out and the way you break it up is that you whack one of these guys in the back with the butt of your gun. Ow, that hurts. He gets off and you are not prosecuted because that was the lawful use of force in defense of that poor one guy who's been jumped by the three. He was not at risk of death. They were just kind of beating him some and they were going to leave him alone. You used a gun, but you used a gun as a bludgeon. You understand where I'm going because Ares, if deployed incorrectly or correctly in a deadly way, can be deadly. You spent some good time with witnesses exploring that fact that a canine can be a deadly weapon. The way Ares was deployed here to the arm, were unlikely to result in death in the same way that OC really wouldn't be unless you then fall or you have, they didn't know, but you have this terrible anaphylactic shock to the OC and you die. So why do I need in assessing this to get tangled up with intrusiveness? Was it deadly or not? Other than the fact that, you know what, a canine could be deadly and there may well be a time when an officer to save his own life or protect the life of a colleague deploys it in a deadly way. Not because it's an officer, it just happens to be an officer who has the dog, but says, Ares, I need you to take this person out, not just down. But that wasn't what was going on here. And so I'm wondering why you're pulling me into the area of don't think of this dog as the same thing as pepper spray, because it's not. And this binary, you know, it's either lethal or non-lethal, and someone's saying there's a sliding scale. All that, I don't know that we need to get into if you agree with me that it could be a gun, but if the gun is used in a way that wasn't in any way intended to be lethal force, then we're not in that prong of self-defense where that degree of force, lethal force, has to be justified by the fear of death or serious bodily injury or forcible felony.
Well, I think the question is, what type of injury did the person suffer as a result of getting hit with the gun?
Okay, but if the person, I mean, then go back to my OC spray. It's not lethal, but I spray it and in the end you fall over and hit your head on the curb and die. That was a lethal injury. That's not what I meant. As opposed to if I shoot you in the head, I'm getting it that you will likely die as a result of that. But that was necessary because you had a gun and you were shooting at my kid.
Well, I think the difference is that if I use a gun to hit someone with, that's a heavy object. And to hit someone with a heavy object could result in a serious injury. So I don't think, respectfully to the court, I don't think it's comparable to the OC spray, because if the OC spray is used as directed, it won't result in a serious injury. But if a dog is used as directed, it's likely it could result in great bodily harm. And I think that's the difference here.
Okay.
And I think Dr. Adams testified to that.
So then I guess we should talk some about great bodily harm, because I know I wanted Ms. Palmer to stay away from serious bodily injury only because I don't know, it was real productive to try to characterize Mr. Moya's injury as anything other than serious, because you had to go to the hospital, and Ms. Moya talked about the many weeks of wound care in which she had to engage. That's different from the paper cut where a Band-Aid and you're done. But if there's going to be argument, it sounds like there is, was this great bodily injury or risk of great bodily, or you used a force that could cause great bodily injury, then it does seem like it depends on how the dog was deployed and the duration for which the dog was deployed, et cetera. And ultimately, was it, and what was the nature of the injury? But maybe I'm wrong. You tell me.
Well, I think the nature of the injury speaks for itself. That as we see what caused the injury and the result of that injury, and we saw how that injury arose. That is by deployment of the dog, but maybe I'm missing your
right. But we have several witnesses who under oath said that really wasn't a very bad dog bite. I've seen a lot of dog bites. That one wasn't so bad. We have pictures of it that to a layperson say, gosh, that looks terrible. But how do I navigate that then? Because if the intent was to not use deadly force, so we're out of that prong of self-defense, then it's a different standard. How do I navigate that?
You know, and I think it says, the statute says, and the court has to make this interpretation. It says, which is likely to cause death or great bodily injury.
Right. And great bodily injury. So what does that mean? Is great bodily injury the arm was removed? Or is great bodily injury, it bled this much, it needed 10 stitches, it needed 100 stitches? Because if it's not great bodily injury and that wasn't the intent, then it is a different burden of proof that the defense needs to meet by a preponderance. And I'm asking you to tell me why you think we're in the death or great bodily injury prong, other than res ipsa loquitur, look at the injury. But I don't know the reason people might disagree. We had some people say that was terrible, and other people say, you know, when a dog bites, it's going to create puncture wounds and you're going to bleed, but that's not great bodily injury.
I think that it is a jury question that when, you know, that's why we have leash laws, because if the dog bites somebody, it could result in serious bodily injury.
Okay.
So I think that is a jury question here. I think it is reasonably likely that if a canine bites someone, it is likely to result in a serious or great bodily injury.
Those aren't the same thing, or they are the same thing?
I think they're the same thing.
Okay.
Now, I don't know if the court wants briefing on that. I believe I looked for it, couldn't really find great distinguishing factors, but I think that is a question for the community, for the jury.
Okay.
Right. So now let's go to what the intent of deployment of the dog was based on the testimony of Mr. Esposito, which was his intent was to arrest, gain compliance, and control, not primarily to defend the other officers. That's when he's talking to Ms. Moya.
Okay, Ms. Moya. Okay.
And that is initially when he's talking to Ms. Moya. I hope it's loud enough. You know. It's not.
It's not. And I can't control the Zoom.
What I'll represent to the court, I guess our technology glitch here, is that he, at this time that the defense wanted to make much of, that Ms. Moya's interaction with Officer Esposito, what he testified to was that he was, after Mr. Moya started, he described it as fighting. He stated that he had to, and his officers could not handle it, that he had to gain Mr. Moya's compliance so that he could be handcuffed. Now, he wasn't saying he was threatening my officers. He did say he balled his fist, He did say that, but he did not say anything such as to the extent to say that my officers could not defend themselves and I had to jump in to defend them. In regards to him defending himself, Your Honor, he is the furthest away of all three officers.
I haven't heard Ms. Palmer say that this was first degree, as in primary, protect Officer Esposito. I haven't heard her argue that. It's been the three officers there, and then maybe secondarily, Esposito, people in the house. If, as I said, Mr. Moya got in the car, whoever might be at risk there. But the primary focus was the three who were unable as a threesome to get control of Mr. Moya.
Well, if the court's going to reside there, then I'm not going to push it.
Okay.
What I will suggest to you is this. If the officers felt they could not defend themselves or handle that situation, I think they would have asked for help from Mr. Mr. Esposito, and they didn't. Because this happened the deployment was so fast, so quick, he barely gave the officers a chance. And quite frankly, if you're one of the officers and Mr. Esposito is about to deploy the dog, I think you're going to get out of the way. I think that was reasonable for them to get out of the way at the time. As according to Dr. Adams, it was the deployment of the dog. And again, there is no suggestion here from any of the officers that they felt threatened to the extent that they needed some help from the canine under those circumstances. Esposito testified to the same on the witness stand, Your Honor. He was, again, we're probably going to have technology glitches out of this one. It's not loud.
That's all right. I mean, it's in the record, and I was there.
So let's talk about threat very quickly. And now we can talk about threat from a reasonable person standpoint, not necessarily a reasonable officer. I think it is perfectly logical to look at this situation to see if Mr. Moya was a threat. Well, did he have the ability to carry out any of the threatening acts that Mr. Esposito said? Headbutt, kicks, headbutt, kick, and rolling, and all of that. But even if he had the ability, the question was, did he take the opportunity? And there's nothing showing that he exercised any opportunity to do anything other than lock his arms after he had spun around and was taken to the ground. If he was such a threat at the time that he spun around, then that conceivably would have been, I'm not saying it would have been appropriate, but it probably would have been more appropriate to deploy the dog then than when he was on the ground in a prone position, in a plank position. It seems to be, it'll be a lot harder to headbutt someone who is not standing near your head from a prone position on the ground than it would be standing up. It would be a lot harder to punch someone when you're in a push-up position. Excuse me, when you stand, it would be a lot harder to hit someone or punch someone when you're in a push-up position than standing up. And almost a lot harder to kick someone. So he certainly, when he is on the ground in a prone position, he is not exhibiting any motive except to remain still and to pull his arms back, not to lash out or take any affirmative offensive actions against the officers.
And you think a reasonable person, not officer, but reasonable person in that situation ought to wait to see if this is going to get worse before using force to try to protect the folks he perceived were at risk?
Yes. And the reason is,
I mean, doesn't green stand for, and I don't want to overstretch green, but there are cases, I believe, in the self-defense context that stand for the proposition, you don't have to wait for the threat. This is what Ms. Palmer was getting at. You don't have to wait for the threat to materialize into, he actually now has his finger on the trigger. All right. It's not enough to know that the gun is in the drawer. It's not enough to see him walk to the drawer. Not enough for him to open the drawer. Not enough for him to grab the gun. He actually has to turn and point. And I mean, the way you're arguing, I guess he has to pull the trigger. And here, would he have to have punched one of the officers on the ground for then Esposito to say, oh, you know what? My concern about his wrist, or gouge an eyeball. So now we've got a colleague, a friend, a private citizen, doesn't matter who it is, who now is sightless in one eye because intentionally or not, that's the way that this person who is refusing to comply lashed out. I'm confident the law isn't, you got to wait for there to be harm. It's the threat of harm.
It's the intrusive level of the harm.
Well, where does intrusiveness fit in here now?
Sure, Your Honor. If somebody punches me, I can't just pull out a knife and stab them. Especially if there's 3 people around, 3 on my team, and the guy swings at me, I can't pull out a knife and stab him.
So it's proportionality.
That's what the Fourth Amendment says in terms of intrusiveness. In terms of somebody being on the ground, is because he's resisting now. If they trying to, not 17-420 is different. We're not talking about 17-420. We're talking about 16-321, defending myself. We're not talking about trying to get him to comply.
Right.
If he's in a prone position, in a push-up position, can the lay person just walk up and kick him in the side? If 3 people are already on him? No, he can't do that. That would be deemed as unreasonable to do that. Again, we're not talking about officers exercising their lawful duties. We're talking about, as a matter of law, he's entitled to immunity and shouldn't stand trial under the 16-321 defense. So defendants are still saved by having a whole plethora of arguments. They can still argue that come trial. The question is, does this court want to pass on this to say, you know what, the guy's sitting on the ground in a push-up position and he's resisting, yeah, just drop the dog on him, just right away. Well, court has to be careful, again, with that. Because the standard is, does the subject's conduct constitute, quote, an imminent use of unlawful force? And where the court has to conduct an analysis of the threat of force needed by the deputies to reasonably defend against such force. Assuming Moya was exercising force, was it so great that you have to deploy the dog on him? That's the question. And the answer is no. This is not a case as a matter of law. He should not stand trial for this. The level and extent of the force used must be reasonable. I look at the case of Richards v. State, 288, Georgia Appellate 814. There's a pinpoint site in here where it states, here, even if the victim initiated the fight and the defendant would have been authorized to use some force to defend himself, the amount of force he used must not have been excessive for its quality as a self-defense. It's relying on 16-321 and goes on to say, which provides, and it cites the statute. I'm not going to read that. The court finishes with, the defendant, Richards, would have been justified in stabbing the victim only if he reasonably thought it was necessary to avert death or great bodily injury to himself. Not saying this is a case where someone died. What I'm saying is that Esposito is justified in deploying a dog with sharp teeth who is going to thrash only if he thought it was necessary to stop his fellow officers from suffering some level of bodily injury, certainly higher than what Mr. Moya displayed, or even threatened, or what Esposito says he threatened to display. Based on that, Your Honor, we think that it would be, we ask the court not to rule that as a matter of law, Esposito was justified in deploying this level of force at that time. This case should be reserved for determination by a jury if he continues to want to assert the immunity defense, and he still has other defenses here, including 17-420. But we don't want to mix 17-420 with a 16-321 defense. We ask the court not to conflate the issues as directed by State v. Copeland, and that you deny this motion.
Thank you, Mr. Watkins. Ms. Palmer, is there anything you want to say in the next 10 minutes-ish in rebuttal, or you've said what you want to say?
I just want to say maybe 5 minutes, few discrete points, and I'll be done.
Okay. If you could start and then go to your discrete points with something that Mr. Watkins and I wrestled with, and I mean that in a positive way, because I'm clearly susceptible to it. Thinking about this as, yeah, you needed to do this, Officer Esposito, to effect the arrest, and was that use of force justified under the, I don't know if it's the 17-4-20 rubric, but it's not the self-defense rubric. It's the, was this a lawful use of force to get someone into custody? And the more I think about the bulk of the expert testimony in both directions, it was a lot about that I'd do the same thing. This guy needed to be, it's a tier 3 encounter, et cetera. In fact, you started walking me through the tiers. And I think that's all, I don't want to say it's irrelevant, because it's part of what happened. And it's certainly the way in which your client and the other 3 officers would be thinking about this. But when you invoke immunity, it seems like we have to step away from the law enforcement piece of it, which is artificial, because I don't know, I hope we wouldn't have many situations where there are these people scrapping on the ground. I guess it could. This guy's got his pit bull. It's like, I'm going to use my pit bull to break this up. This is a trained dog, it's a professional dog, and a professional handler. And I certainly need to consider that. But it's not, I don't think it's right. And I want you to push back if you disagree, to be thinking about it like, hey, all they're doing is arresting this guy and whatnot. Immunity is the use of force to protect yourself, your habitation, or protect others from, and it's a litany of things. And that's not, I'm arresting this guy. It is keeping Fruden safe, and Melee safe, and Benfield safe, maybe the kids in the house, all the things that I've talked about. But it's that, and it's a different framework, and it's hard to decouple them, but you coupled them a lot in some of your arguments that I thought were persuasive. So just tell me how you think I ought to navigate that. I don't think you disagree with Mr. Watkins that they're 2 separate analyses. And even he struggled with it, because it's back to the intrusiveness. Like, intrusiveness, that's if you're suing the cop for unlawful use of force, not the officer is being prosecuted for aggravated battery. Then the one defense would be self-defense or defense of others. My colleague, myself, yeah, I pepper sprayed you because you were coming at me with an axe. Okay, I'm probably not going to prosecute that person. So.
Right, Your Honor, it's because 2 things can be true at the same time. And that's what we see here. So yes, I'm going to travel under 16.3.24.2 and 16.3.21. But we are also talking about police-citizen encounter, and the tiers are relevant for that word unlawful in the statute. That's what Larsheed makes clear. This was unlawful force. And when my client describes to Cami Moya at the end, look, when he's balling his fists at my officers, I have to use a tool. He's speaking to her as a law enforcement officer, but he's also reasonably believing in his mind that that tool was used to defend against imminent force against his fellow officers. He doesn't have to articulate that. That is clear from the competent evidence and testimony before the court. And 2 things can be true at the same time. You don't have to consider his role as a law enforcement officer to find for us under these 2 statutes. And I do want to make a few points as to these specific statutes, because I think we got a little bit astray. But certainly when my client is on scene in uniform effectuating an arrest, he's going to speak as a law enforcement officer. But that doesn't change the fact that any reasonable person in that situation would believe that imminent unlawful force was about to occur and that there had to be a use of force, that is the directed bite, to prevent harm from the other officers, to prevent that force being used against the other officers, the third parties. And so I think both can be true. We don't have to find one or the other, but the analysis under the statute before the court, what we've
imminent unlawful force could be private citizen against private citizen. It also can be unlawful force. I mean, we view police officers as well. That's what they too are people. And if you punch a guy in the face, that's unlawful force. It's often characterized, oh, that's obstruction. Okay, it's also assault. And so we need to, in some way, strip away the badge and the baton and whatnot, and say if there is, it's reasonable to believe that there is going to be this use of unlawful force coupled with some unlawful force that maybe has already been used, then thinking about it as defense of self or others makes sense, even though, as you say, two things could be true at the same time. It might also be justified, or it could be more problematic on the police use of force side and less problematic on the defense of others side. But it doesn't need to be. It just, you agree that the analysis is defined by 16.321 and cases that interpret that.
Yes,
Okay.
in cases that interpret that, they do look at law enforcement, particularly. The burden remains the same, the burden that we met, but what they look at is whether the suspect was exhibiting unlawful force. In Larsheed, they said it's clear that this woman was exhibiting unlawful force, so you've met that burden right there. But you don't, the standard, the reasonable person standard, that's Officer Esposito. It's also Michael Esposito, just a regular person watching everything. And in both capacities, he looked before him and believed he had to use force, that is a directed bite, to protect against the imminent use of unlawful force against a third party. That was certainly the three officers on the ground and potentially others. And so both of those are true at the same time. And here, I think, the state started off by saying, let's not get into the weeds about some of these Fourth Amendment issues or civil rights cases, and then cited a number of them. I mean, Glenn Corbett, he also testified in Larsheed to the same things about policies and procedures and the tier issue. Brad Smith is a canine expert, but at the end of the day, what Your Honor is able to find with what's before you is Officer Esposito's body-worn camera, Officer Fruden's body-worn camera, both of their testimony, and Officer Esposito's absolutely reasonable belief, based on the circumstances in front of him, that unlawful force was imminent, and that he used reasonable force to prevent against that imminent force against others. And that's what 16.321 is all about. And just to clarify here, I believe that the state spent much time talking about using force necessary to prevent death or great bodily injury. But what the statute says is that you can use force intended or likely to cause death or great bodily harm only if the individual using such force believes that it's necessary to prevent death or great bodily harm, or to prevent the commission of a forcible felony. And just so that we have an understanding.
Well, that's why I asked Mr. Watkins if he concedes that felony obstruction would be a forcible felony.
And
because I assume that of the three, there's the hypothetical, Mr. Moya gets a gun, and so then there's the risk of death to others. But in that moment, that I don't know that anyone articulated that, or that there'd be a basis to articulate. We knew he was a black belt in jujitsu, so with his hands he could kill someone. It would be the forcible felony prong that would justify the use of force that would cause great bodily harm. If, it's a big if we all agree that deploying the canine was the use of force that could cause or was intended to cause great bodily harm. I don't know that we fall in that category. That's why I engaged with Mr. Watkins some about great bodily harm and how that works. And he said, look, the cases don't give us a lot of help in defining that term.
And I think that additionally, what the state focused on was that, well, yes, it's a forcible felony, but right here we didn't have one. And that's just what I want to clarify for the record, that both when it comes to this idea of defending yourself or defending third parties against the imminent use of unlawful force, and similarly, under the felony obstruction OCGA 161024B statute, we don't have to wait for something to happen. There is a parallel here. And so I do want to make clear that the Green case says a mere threat of force is all that's required when one reasonably believes he must defend himself against another. And so you don't have to wait for that contact. And then similarly, Singleton versus State, that's 390 SE 2nd 648 or 194 Georgia App 423.
Can you say that one again?
Sure. And I'm going to give it two that I think are on point here.
Don't give me the SE site though. Give me the.
Sure. 194 Georgia App 423. That's Singleton v. State. And then that Singleton v. State was cited by, and I think this one's on point, Smith v. State, 294 Georgia App 579. And it says violently struggling with officers during an attempt to arrest suffices to show that the accused offered violence. It's the offering. And the plain text of all of these statutes is what controls here. The plain text of 16.3-21, the plain text of the felony obstruction statute, both make clear that you don't have to wait to have the force make contact with whomever you are trying to defend against. You don't have to wait for somebody to do violence to the officer. The offering alone is enough. And similarly, under the self-defense statute, the imminency of the force is enough. And here, rather than waiting for the suspect who is clearly non-compliant to kick or to punch or to do all of the many things that he could have conceivably done, Officer Esposito or Michael Esposito reasonably defended third parties by using force that was necessary in this situation to prevent that from happening. So any argument that we have to wait for that moment is contrary to law. And in this case, we have more than met our burden of a preponderance, and the case should not proceed. We should not have to wait to trial. Your Honor has every reason to go ahead and dismiss the indictment at this juncture.
All right. Thank you. Are you Mr. Moya? Mr. Moya, it's nice to meet you. We didn't get to interact. I just want to let you know, and I suspect I'm speaking on behalf of almost everyone here. What happened was unfortunate, justified or not. I hope that you are doing better. Whatever the outcome is here or a trial, the events of that afternoon, I suspect everyone regrets. And so I'm hoping that you are moving forward with it as best you can. All right. Same with you, Mr. Esposito. I know you continue to wrestle with things, and none of what we've worked through here has suggested to me in any way that you showed up that day hoping someone was going to get hurt. That's never your goal. It's to help. And this unfolded in a real complicated way. And that's why with good lawyers on both sides, we're all wondering, what did this mean? And it is all an exercise in second guessing. For everyone, from Ms. Moya to Mr. Moya to you to Fruden and others. And it's a tough spot for all of us to be in. But I appreciate the work that Ms. Palmer has put into this and Mr. Watkins and his team. And I will get an order out soon. I think this case is on the March trial calendar, March 21. Obviously, if I haven't ruled by then, there's not going to be a trial. But my goal is to get a ruling out shortly so that if there's going to be an appeal, there can be that. If there's not an appeal and my ruling keeps the case alive, folks have ample time to prepare for that. Mr. Watkins, do you have any procedural points you'd like to make? Okay.
Two, in regards to trying the case for the week of the 21st.
So the 21st is actually a Thursday, and that's when we call the calendar. It's a 2-week calendar, and it would be the 2 weeks. I believe it's a 2-week calendar. It'd be the 2 weeks after that.
Okay. I'll ask the court that I did file leave of court. I'd be granted leave on that. If I can have another ADA standing at that time, I will primarily be responsible for the case.
Okay, so you have leave just for the day of the 21st, the call of the calendar.
22nd, that Thursday and that Friday.
Okay, that wouldn't, if this is a case going to trial and it were to go that week after, you're good. You do not need to be the person who comes to the calendar call. All that's happening on the 21st is the call of the calendar, people announcing ready, not ready. If it's resolving short of trial, it's better to resolve it then and not when we've got jurors sitting around. And this is all a hypothetical conversation anyway, because I have this threshold issue to work through. But don't worry about your leave. That won't interfere with your ability to be lead counsel at trial. It might mean that if you're on a trip, you're spending some of your trip thinking, I'll be picking a jury the Monday I get back. But there are older cases with defendants in custody ahead of Mr. Esposito's case that would likely take precedence if they don't resolve, meaning the in custody cases.
And Ms. Palmer has a expert witness from out of state. I don't know if she wants to continue to use Mr. Smith. And although my witness is just the next state over, he does
fly everywhere all the time.
Yeah. So,
yeah.
You know, I guess we can wait to hear from the court, but the state may be asking for a specially set date.
Okay. I'm not categorically opposed to specially setting things, but I tend to do those for old jail cases because I need to ensure the lawyers will be here because someone has been in jail for 3 years with the presumption of innocence in his favor, and that burns me up. And this has been hanging over Mr. Esposito's head for a while, but he at least enjoys general degrees of freedom. You know, he's on bond or whatever it is, but you're not in custody. So I just need to, I can only specially set so many. Otherwise, I'd say, sure, I'll specially set it for November, and no one wants to wait till November. So we'll see. But I will certainly work with schedules, and we can always have people Zoom in. And that's it's a joint decision. I'm not imposing a Zoom appearance on anyone, but you know, hopefully you both sides will use your good judgment to say, you know what, the jury's going to be just fine having the witness on a big screen right there, as opposed to here in person to see the beads of sweat on his face when he's being cross-examined.
Thank you.
Those are the two things?
Yes.
Okay. Ms. Palmer, anything procedurally?
No, Your Honor.
Okay. All right. Well, thank you, everyone. Have a good weekend. Ms. Nelson, should I leave this Zoom up because it's what we'll use for the afternoon?
Sorry, it didn't go smoothly.
Technology, I didn't record it loud enough. And I thought about it like this morning. I was like, oh God, I can't go back and use it.
Let me look.
Yeah.
I think so. So I'll just mute it in here.
I believe we only have one Zoom link for the day.
Ms. Rivers, can you hear us from the courtroom?
Yes, Judge, I can.
Great. All right. Well, we are all here. Ms. Primovic is speaking with Mr. Butler right now. And then when we clear that one up, we will turn to the Jonathan Carter case. Is anyone here for that case?
I'm sorry, Judge.
Oh, I know you're here for that.
Judge, the attorney is running a little late. They were caught in traffic, but they'll be here shortly.
Yep, I got that email. Thank you. Is Mr. Carter in custody? Anyone?
No, I don't believe so.
Okay, maybe he's coming with his client.
Able to finish the hearing this morning, Judge?
Yes, thank you for asking. The guy who got bit by the dog ended up not testifying. That's what was left, was the state was calling that gentleman. He was here, but they decided they didn't need or want his testimony. So it was argument, but it was lots of argument. It took a little while. Now I have to figure out what to do.
I saw that one is on the trial calendar for March.
It is. So I'll need to figure out what I'm going to do before then. Hey, Ms. Primovic.
I tried to see him yesterday, but that didn't work out very well.
Okay. Thank you, everyone, for adjusting your schedules a little bit. I couldn't hear what was being said, which is good, but I could hear that Mr. Butler was sounding a little animated. Are we able to go forward today with anything, or what's your sense of what's going on?
I'd like to talk with the state about what the offer would be. I think we could go forward today if we have the right thing. He would like to go back to Memphis I will get him a bus ticket. We will have we just did this Tuesday, have an investigator pick him up on Monday, take him to the bus station, wait for him, put him on the bus and take him to Memphis.
And then he's-
I'd like to do, if the state is willing to.
Okay, I don't know.
That's what I'm gonna counter. Like,
Okay.
But we can get him through a plea for sure.
Okay. Well, why don't you guys talk outside my earshot about what makes the most sense? I don't have I do have booking numbers on here. So if Mr. Butler hasn't gotten out, he's been in for over a year. It's a 22 booking number. I don't know if it's a bench warrant case, but otherwise he's been in for over a year. But why don't you two talk for a little bit and let me know if this is something that can go forward. It's the final plea date, so it also could be non-negotiated, and Mr. Butler would have the ability to withdraw his plea if it doesn't go the way you set it up for him. But it would be good if you two spoke so there aren't surprises.
Sounds good.
Great. You can go to the jury room, wherever you want to go.
That's good. Everything looks okay.
Question.
Is it AC? One of the prosecutors had it.
AC?
AC, yes.
Thank you.
How are you today?
Awesome.
What's going on? Good. How the heck is everything?
Crazy.
You in the country?
Yeah. Let me, I need to find out who that person is. And I just want to- That's when I did it, I didn't. Oh, just McBurney. The public defense assigned short.
Ms. Wood and Ms. Feely?
Okay.
How are you doing, Judge?
I'm well. How are you, sir?
I'm doing well, Rick Willis. I sent you an email thinking I was gonna be late because we got rerouted because of a big accident on 85.
Yep, you did. And everyone let me know we're going to handle one thing before we turn to your client's situation. Where is Mr. Carter?
He is either in the building or getting out of an Uber. I talked to him and told him my situation too.
Great. Okay.
But
No
I'm
one's
happy to be
late.
here.
We're going to see if we can take a plea on the case ahead of Mr. Carter's. And then looks like we've got law enforcement here, prosecutors here. She's talking with a public defender on this other case. And we'll turn to Mr. Carter's case.
Sounds great, Judge McBurney. Thank you so much.
Mhm. That's right.
Your Honor, can I go ahead and start setting up, or you need that table for the plea?
No, we'll have Mr. Butler up at the podium, so you take over that table.
Thank you, Your Honor.
Ms. Primovic, we able to go forward?
I think we're gonna have to do it blankly, Your Honor. I'm gonna talk to my client about that, having a look at the indictments and stuff now. So
Okay.
we're on blankly whenever.
Do you have copies of the indictment or you got them on the screen? Okay. I can try to pull them off Georgia, Research Georgia. It helps.
That's agreed. That's agreed.
Yes.
I do have not been this week to place the axle.
Okay.
Conditions are anger management and no contact.
Yeah, there's no way he's gonna take that tab, and I'll run it by him, but I mean, obviously, we got some time to think about it, we can make some decisions on it. So 10 to 1. Okay. So you would not do probation on this case?
Will be,
I understand that, I'm just saying, you're not gonna go straight probation on it.
no.
Okay.
If you want to send me a counter offer, I can consider it.
Okay.
Sometimes if it has conditions, then I can convince people, victims who want to kind of be okay with that kind of thing. That's very rare today.
I understand. I think she's police in situations, so I'm aware of she's pressing what she's told my client many times, she's gonna get him to do. She's gonna prison.
Got the evidence.
Sounds good. Did you not get my email? Sent a few of them to you. I think I got your email from one of your colleagues, sent me your email and said to contact you, not her.
I got the.
Okay. Yeah, since, well, your colleague sent you another email from me. Christina, does that sound right? Was it?
Christina.
Yeah, that sounds right. How's your office been these days with all the craziness?
Getting a little bit better. So we can actually use the printer now.
I'm not laughing at you. I'm just laughing. It's getting better. That's a good thing. A lot of things happening right now.
Yeah, I don't see anything else from you.
What's that?
I don't see anything else from you.
He texted me. He was getting in the middle of Texas. It should be here in a second. I haven't looked at my text in a little while.
And was this a notice calendar?
I don't know. Let me find out. Please.
Come on.
Hey, Mr. Butler. All right, come on up to the podium, please. Right on up there. Whoop, you want to slide back towards the deputy a little bit? Ms. Brunvik's going to be on your other side. Ms. Rivers, are you ready?
Yes, I'm ready. Can counsel at the defense table mute his microphone, please?
Yeah. If you're going to be at the table, which is fine, we just need to have that thing turn red.
I'm gonna go to the bathroom.
Okay, but let's turn it red anyway. Great, perfect. Okay. Mr. Butler, Ms. Primovic tells me that you are prepared to go forward with what's called a non-negotiated plea, which means if I accept your plea in these two cases, these are old cases. I'm hoping you remember what they're about, but we're going to talk about them. If I accept your plea and I sentence you to something more than what Ms. Primovic asks for, you'll have the ability to say, no, thank you. I'd rather stay where I am and wait for trial. Because of course, that's the next stop for you, is to get you a trial if that's what you want. But Ms. Primovic is saying that you would like to try out this non-negotiated plea. And I'm going to make the numbers up, but Ms. Primovic might ask for 1, and Ms. Nix, the prosecutor, might ask for 3. And if I give you more than 1, you'll be able to say, no, thank you. I asked for 1. I was willing to take 1, but you gave me 2. That's more than 1. So I'm going to withdraw and let's go to trial. We won't go to trial today, but we'll go to trial soon. Does that make sense, what I just described?
That makes sense?
I don't understand. I just want to go home.
Okay, so I did a bad job of explaining that. I suspect that Ms. Primovic is going to recommend that I give you time served, that you get out, get on a bus to Memphis. And that's what she's going to argue for. If that's the sentence I decide to give you, we're done. You've pled guilty, and we move on. If I decide a different sentence, and I'm making this up, just pretend with me. I say, you need to go to jail for 5 years. You can say, no, thank you. I was willing to go home, but I don't want 5 years. And then we'll go, okay, it's like this never happened, and we'll figure out what to do next. Does that make sense? That was a better way of explaining it? Yep, you just got to say it out loud.
Yes, sir.
Okay, got it.
Thank you.
You're welcome, but I haven't decided yet.
I know.
Okay, good. So Ms. Nix is the prosecutor. She's going to swear you in just a moment. Once you are sworn in, she's going to ask you some questions. I may have a few questions, and then we'll make sure you understood what we talked about. Does that work for you?
Yes, sir.
Okay, important. If at any time you don't understand what someone said, let Ms. Primovic or me know. Just like you said, man, I don't understand. That's good. Let me know that you don't understand, and I'll try to explain it in a different way, okay?
Yes, sir.
Excellent. Most of the questions are yes or no questions. They're not, what's the capital of Nebraska or something like that. I don't think anyone's going to ask that. But if we do, we'll figure it out, okay?
Yes, sir.
All right, Ms. Nix, when you're ready.
Yes, sir. Before we get started, I wanted to make sure that it was noted for the record that I know there's been some competency issues in this case, and we've had some previous discussions, I'm not sure on the record or off the record, that the most recent evaluation from the Department of Behavioral Health, is that who does it? The last report from them was that the defendant was competent.
Yep.
And so I just want to make sure that that we're all under that impression.
Right. I mean, that's the only way we would go forward, is because there's been a medical professional who's determined competency. I'll be making my own observations, and I may have a few questions for Mr. Butler, but thank you for framing it that way.
Right. Mr. Butler, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Correct.
Please state your true, correct, and legal name.
Antonio Alexander Butler.
Okay, you can put your hand down now. Thank you.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
I took my medicine this morning.
Does taking that medication affect your ability to understand this proceeding?
I don't know.
What do you take the medicine for?
I take it for paranoid schizophrenia.
Okay, and when you take that medicine, does it calm you down and make it easier to understand what's going on? Or does it get you excited, or what does it do?
It got me anxiety. I have anxiety. I'm on the wrong medicine.
Okay. Have you been understanding the things we've been talking about for the most part this afternoon?
Correct.
Okay.
Correct.
Great.
I'm telling you the truth.
I don't doubt that.
How old are you?
31.
How far have you gone in school?
The 8th grade.
Is English your native or dominant language?
Yes, ma'am.
You understand that you've been charged with the following offenses in indictment number 23 SC 187649. Count 1 is obstruction of law enforcement by use of threats or violence.
Correct.
And in 23 SC 187745, count 1, criminal attempt to commit arson in the first degree.
Correct.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial.
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
You need more time to discuss the case with your lawyer, Ms. Primovic.
No, man, I just want to just go get it over with.
Are you satisfied with Ms. Primovic's services?
Yes, ma'am.
Ms. Primovic, do you waive a formal reading of the indictment for purposes of the plea?
Yes, ma'am, we do.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes, ma'am, we do.
Mr. Butler, do you remember having been arrested on each of these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Correct.
Do you understand that your plea of guilty today is called a non-negotiated plea, and the state may recommend a sentence to the court even without your having agreed to it in advance?
Correct.
Are you aware that the state's offer in this case is a 10-year sentence with 2 years to serve with the balance on probation?
Correct.
Have you discussed this offer with your attorney?
Correct.
You understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state?
Correct.
Do you understand? The judge can do whatever.
Okay, I don't understand.
So what she was asking, Mr. Butler, what she was explaining to you is that your lawyer is going to recommend, let's get Mr. Butler home. We call it time served sentence. Let's get him home. Ms. Nix may recommend something different, maybe more jail time. I don't have to do either one of those. I could agree with you. I could agree with Ms. Nix. I could say, you know what, 10 years. I don't know that I could give you 10 years on one of them, but let's say 5 years. But remember, you get to say no, thank you, if you are unhappy with the sentence you get. Does that part make sense?
Okay, that makes sense.
Yeah.
Okay.
Okay. Ms. Nix?
Right. You understand that if you enter a non-negotiated plea, you have the right to withdraw your plea of guilty once the court enters its sentence?
Correct.
Do you understand that this is a plea of guilty, which is permanently recorded on your criminal history?
Correct.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you are placed on probation, you cannot violate any criminal laws of any governmental unit?
Correct.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Correct.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Correct.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Correct.
Are you a United States citizen?
Correct.
You understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm.
Correct.
You understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years.
Correct.
You understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future.
I know. Correct.
I'm sorry, what did you say?
Correct.
Okay, so correct.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Correct.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yeah. Correct. Correct.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Correct.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of obstruction of law enforcement officer by use of threats or violence in 23 SC 187649?
Guilty.
And how do you plead to the offense of criminal attempt to commit arson in the first degree in 23 SC 187745?
Guilty.
Are these guilty pleas freely and voluntarily given with full knowledge of the charges against you?
You know everything about your charges.
Yeah. Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition within 4 years from today.
Yes, ma'am.
I'll start with a factual basis in 23 SC 187649. Judge, had this case gone to trial, the state would expect the evidence to show that on or about the 21st day of September or the 20th day of September, the defendant was an inmate in the Fulton County Jail at 901 Rice Street, which is in Fulton County. He approached Officer Jefferson and struck her about the head or the face while she was engaged in her duties as a law enforcement officer with the Fulton County Sheriff's Office. And that occurred in Fulton County. In 23 SC 187745, had that case gone to trial, the state would expect the evidence to show that on or about April 20th of 2020, while in Fulton County, the defendant went to the Family Dollar and he was in possession of several containers of flammable liquid and a lighter, making threats to burn the store down. The officers arrived and defendant said to them that he was intending to burn the store down, and they confiscated the flammable liquid before it could be used to burn down the store. This was a substantial step in furtherance of committing the offense of arson, and that occurred in Fulton County.
All right. And the state's recommendation?
The state's offer in this case was originally 10 to serve 5 years. Then we changed to 10 to serve 2 with the condition that the defendant complete behavioral health treatment court. The maximum sentence in the arson is 20 years and the maximum in the obstruction is, I believe, 10 years.
Attempt.
Yeah, the arson is attempt, so it may be a 10-year cap. None of your recommendations is outside that range anyway. And I don't do a lot of arson cases, but if arson normally is 1 to 20, then the attempt would be something less than that. But it would be at the least 10 years, and your recommendation is 10 to serve 2.
So the the state is concerned in this case about the defendant's mental health and his continued continuing to engage in criminal activity that may or may not be better controlled on his medication. And so we would ask that whatever sentence the court imposes, that it includes mental health treatment and continuing to take his medication. We'd also ask for no contact with the Family Dollar store, which is located at 1723 Lakewood Avenue Southwest in Atlanta, and that he have no contact with any of the workers there, and also that he have no contact with Officer Jefferson unless it is through the course of her employment as a law enforcement officer.
All right. Got one thing.
Okay. Yeah, this place is a good place. Oh, it's 10 days.
Okay. Thank you, Ms. Nix. It doesn't sound like I wouldn't have wanted to be Officer Jefferson, but it doesn't sound like Officer Jefferson needed medical attention or anything like that. It was.
She suffered a busted lip, but I think that's it.
Okay. So it was more than just a shove. I mean, she got hit enough that her lip was bleeding. Okay. Thank you. Ms. Jackson, do you have any, first of all, good afternoon. Do you have any criminal history information on Mr. Butler?
Good afternoon, Judge. He does have 10 cycles. The last arrest was January the 23rd, 2022, out of Tennessee for burglary and theft. Didn't say exactly what happened to those charges, but he does appear to have a felony conviction. It's in 2022 out of Tennessee for assault. And he does have 2 failure to appears. It's one in 2022 and one in 2017. Nothing in addition.
Thank you, ma'am. Ms. Primovic.
Your Honor, thank you. Your Honor, he's been in custody under 2 booking numbers, 2006495, which is the original arson, where he was in for 354 days. And then under booking number 2217158 for 461 days. So I don't know how he got the arrest in Tennessee in January of 2022. But
well, because he would have been out. He was released on the obstruction charge in April of 21, and he's out and about. He didn't go into custody on the arson, even though the arson is what happened first. At least what I have for his booking, he was booked in on the arson charge in November of 2022. And that fits then with what we heard from Ms. Jackson, that he could have gone back to Tennessee, picked something up in Tennessee, been back down here, or he actually got extradited. I mean, he may have been in custody far more than the 461 if his exit from Tennessee was in custody extradition down here. That part I don't have visibility into. Doesn't sound like you do either, but I see those same 2 numbers, effectively a year on the obstruction and then a year and 100 days on the arson.
Right. Thank you, Your Honor.
Okay.
Your Honor, we're asking for 10 years to serve 2 balanced suspended, commuted to time served, since he's already done it. We're asking for for it to be suspended, Your Honor, and for us to send you a hold order for our office to pick him up, take him to the Greyhound bus station, and have him go to Memphis, where his family is from and his ex-girlfriend's family is from. He has been at Lakeside Behavioral Health Systems since he's been 12 years old.
Lakeside is in Memphis?
Yes.
Okay.
And I looked it up, Googled it and back. He told me.
So it must be real.
He said, Google it. Yeah, it's on the internet.
Don't worry, I'm gonna hear from you. I promise. You get to tell me about it.
And he wants to go back there. We're asking for a condition of the suspended sentence that he has to take his medicine. If he doesn't take his meds, and he is doing it at the jail, he's medically compliant, which is fantastic, Mr. Butler. I think as you know, drug court and BHTC, he is not of the cognitive ability to handle BHTC and the rigorous classes and courses and group setting that he would need to go through. So we're asking for the suspended sentence, Your Honor, take your medicine. He is, just so you know, he plans on going back home and then going to Lakeside Behavioral Health System. And he knew the address and he knew the phone number.
Mr. Butler, I do want to hear from you, but a question first. Is Lakeside a place where you live, or Lakeside is a place that you visit to make sure you get your medicine and get some counseling?
Lakeside, it could be both. It can be both. It could be a program they can go through for a program. You take your medicine there, and they can find you a housing, and you can go. You can take your medicine there. You can eat there. It can be a homeless shelter. You got a lot of programs there. They got a lot of. It's like everybody with care off a lot of care.
Okay. Is it your expectation that if you get back to Memphis that you would try to live at Lakeside, or would you try to live with the family members that Ms. Primovic mentioned?
I will try to live with my family members, or I might go to a homeless shelter or a group home. But if I can't go to a group home or to my family, I will go to Lakeside Behavioral Health System, which I would love to go to. I would love to get extradited there and spend mandatory time there. Like about 10 years there, if you court order me there, I would go there.
Okay. Well, I think we're talking about the same kind of things. Do you have any questions about anything Ms. Nix or Ms. Primovic or I said? No? Okay. Well, Mr. Butler, I find that there's a factual basis for your pleas, meaning a long time ago, we're talking now almost 4 years ago, you had a bad idea of bringing some things to a Family Dollar store and saying some silly things about, I'm going to burn this place down. And that got people concerned, and the police were called. And then a few months after that, it sounds like while you were in jail, maybe the medicine wasn't working quite right. You put your hands on a deputy, a detention officer, in a way that you shouldn't. I also find that your plea is knowing and voluntary, but I want to be careful about how I describe that. Voluntary means no one's forcing you to do this, that you've had a chance to talk with Ms. Primovic and maybe before Ms. Feely, and you very much want to go home. Is that correct?
Correct.
Okay. And knowing means that you feel like you understand enough of what we've been talking about that you are comfortable going forward. Do you feel like you've understood enough of what Ms. Nix said and what I've been saying?
Yes, ma'am.
Okay. Then I'm going to accept your pleas in both cases, Mr. Butler. I'm going to not sentence you that way. What I'm going to do, Mr. Butler, is let me check one more thing. So I want to make sure your sentence is legal. About that noise. Ooh, to the right page. All right. In 23 SC 187649, that's the one where you hit the detention officer. I'm going to sentence you to 5 years. The maximum is 5 years to serve 2 years, but you've already served 2 years. I'm going to give you credit for the 461 plus 354 days. That's more than 2 years. And I'm going to suspend the balance, which means you're not on probation, but I'm still setting some special conditions for your suspension, meaning if you violate the rule I'm about to tell you, I could lock you up like you violated probation, but it's not probation.
Yes, sir.
Number one is you need to take every medicine that the doctors, whether it's at, did you say it's called Lakewood or
Lakeside.
Lakeside. The doctors at Lakeside or any other hospital, if they say you need to take this medication, you got to do that. That's part of your sentence. And number two is you are banished from Georgia with one exception. It's called the Lookout Mountain Circuit. Those are the counties way up north, right along the Tennessee border near Chattanooga. You want to go to Tennessee anyway. I know Tennessee is long and stretched out, but if you decide you want to come back to Georgia, it can only be right around south of Chattanooga. You cannot come to Atlanta while you're under sentence. Do you understand that? I need you to
come back to Atlanta.
never come back to Atlanta. Okay. Do you have family in Atlanta?
Oh, I don't know nobody.
Okay. Well, you know some people apparently, but
Yeah, I
those
know
folks,
some people.
you're not going to see them anymore.
They will have to come see me.
Oh, that's perfect. They can come see you. In your other case, 23 SC 187745, that's the arson, the attempted arson at Family Dollar. Your sentence is 10 years to serve 2 years. But again, you've already served more than 2 years when we add these numbers up. And I'm suspending the balance, but with those same two conditions. Number one, you take your medicine because that's going to avoid stuff like this happening. And then number two, you stay out of Georgia, except for right near the border, near Chattanooga. But like you said, you're not wanting to come back here anyway. You've got friends and support, Lakeside, et cetera, in Memphis. That's going to be your sentence in both cases. That is consistent with what your lawyer asked for. So you don't get to withdraw your plea. This is actually a go home plea. And Ms. Primovic, I'm actually going to hold off on signing the final disposition until we've got the paperwork in place so that my order will be that Mr. Butler is released to an investigator from the district attorney's office. The public defender's office. The public defender's office, heaven forbid, talk to Mr. Horsley. You will get a ride to the bus station and you're getting out on a bus that says Memphis. It doesn't say San Francisco. It doesn't say Miami. It says Memphis. You don't get off that bus till you're in Memphis.
Okay, as long as I get out of Georgia.
Okay, well, I want you to go to Memphis because that's where Lakeside is, okay?
No.
All right.
I breathe now.
Okay, I want you to keep breathing. That's important. Ms. Nix, now that Mr. Butler's breathing again, do you have anything you want to add from the state side?
I guess I know that I asked for a stay away order, but I also asked for a no contact order, and the stay away is, I guess, encompassed in the state of Georgia, but I would still ask for a no contact.
Okay, I got you. I don't think Mr. Butler's in a position to reach out to Officer Jefferson, so I'm going to leave it to the bright line rules of you don't come to Georgia except for right around Chattanooga.
Chattanooga, that's it.
And you take your medication.
Yes, thank you.
You do that, then you're not violating your suspended sentence. I got 8 years to work with, so you're going to want to make sure you take care of that. And hopefully you being back in Memphis is a healthy thing for you. You stay on your medicine and you're going to be in a better space, okay? Ms. Primovic, anything else on behalf of Mr. Butler?
No, you.
Thank you for filling in for Ms. Feely. Thank you, Ms. Nix, for working with Ms. Primovic. Mr. Butler, any questions for me?
You have a blessed day.
You have a blessed day too, okay? Stay out of trouble.
Sorry. Make sure you get some meat. Make sure I get some meat. Enjoy it.
Okay, well, that's Deputy Gordon can help you with the famous sandwiches from the jail. All right, do we have Mr. Carter here now?
Yes, Mr. Carter is here.
I don't know which one is Mr. Carter. Mr. Carter, come on up.
Greg just stepped out. Let me go.
That's okay. He'll come right back, I bet. Mr. Butler. No, this is a motions hearing, so we may hear from, what is to Sergeant? Almost Sergeant? Okay. We're gonna hear from a detective, et cetera. So we'll have witnesses, and Mr. Carter may testify, but he should come on up to the table. You're sitting right there. Don't be shy. All right, let us pivot to two other cases. We are now turning to a motions hearing in 23 SC 190539 and 23 SC 190540. Mr. Carter is the proud owner of consecutively numbered indictments. He is here in court with his lawyer, Mr. Willis. Ms. Nix is here for the state, and Mr. Willis has filed a raft of motions that we are going to work through today. I'm assuming that's the plan. I heard you guys talking a little bit about other things. If we're going forward with the motions, which is fine, there are a few people on the call that I can release. What's the plan, Mr. Willis?
Yes, Your Honor, we're ready for motions.
Okay, Ms. Nix, motions? All right, so Ms. Jackson and Ms. Tucson, thank you both for being here. Early start to your weekend, at least from this courtroom. You're both free to go. Appreciate your time.
Thank you.
All right, take care.
Thank you, Judge. You too.
So, Mr. Carter, in one case, you are charged with possession of alprazolam and a gun. And in the other, it's an aggravated assault and a couple other offenses. So there's the motor vehicle case and there's a different case. Mr. Willis, you filed some motions in both cases. Let's start with the traffic stop case, because I want to make sure I understand the landscape. That's the case ending in 539. I have a motion that seeks to exclude or suppress statements made while in custody without the benefit of Miranda. That's just the name of the motion. As well as suppress evidence obtained as the result of what you characterize as the unlawful stop. And I'll have Ms. Nix or you can sort of just give the basic outline. Obviously, evidence comes from a witness under oath, but as I understand it, there was a traffic stop and the fruit of that stop was drugs and gun that yield the indictment ending in 539. And you're saying that perhaps Mr. Carter gave some statements as well, and they weren't the product of a proper Miranda waiver. Is that the universe of motions that you think we need to litigate in connection with the traffic stop case?
Your Honor, I don't have any written statements of Mr. Carter in the traffic stop case.
So he may not have given a statement, but you are being abundantly cautious, as you should. And in case what we hear from the detective is, oh yeah, he confessed to this and I asked him about that, you're going to want to see some Miranda hung around that.
Correct.
Okay. So it may be that there isn't substance to the suppressed statements. We'll see what the testimony is, but certainly there were things found in the car with which your client's associated and you're seeking to suppress that.
Yes, Your Honor, we're challenging the stop, the initial stop, the extended detention, the delays in the investigation, making him exit the vehicle, probable cause to arrest, and of course, the probable cause to search. So
Okay.
we're challenging those things.
Got it. And if there's statements woven in there, we'll see how Miranda interacts with that. In the other case, you filed a motion about excluding evidence that may have been obtained through improper video recordings, but it's more a privacy right. It's not that law enforcement did it, but that the alleged victim in the case did it. And then you've got a similar suppressed statements that were given in that. Do you know, is the same thing, you're not sure if statements were given, but if they were, by golly, you want them kept out if they weren't properly obtained?
That's correct, Your Honor. And just to make clear one other thing that we can handle in a motion and limine later, there were some questions about probation about another case that the detectives asked my client about in the traffic stop that I'm of course going to ask that be excluded based on prejudicial versus probative in that case. But that's something we can take up at a later date. I think that happened, if my recollection is correct, before he was placed under arrest.
Okay. Okay. So it would be an exchange, and it may have been just a comment that an officer may like, well, you know, you're on probation and you would want that excluded. But you're right. That's a motion and limine. That's not a suppression thing. Tell me a little bit more about the 16-11-62 motion. Do you know that there is evidence that is arguably excludable, or part of this was, well, let's find out if there's something that's excludable?
No, I was provided discovery that was recorded, video recorded inside my client's home.
Okay. And I need the last name of the alleged victim so I can be referring to the right person.
Ramirez.
Ms. Ramirez. And it's your contention that it was Ms. Ramirez improperly, in a way that's inconsistent with the law, recording your client or the two of them or whatever was happening.
Your Honor, my position is that she broke the law when she did it, and she's guilty of a crime in doing so. And my position is that clearly is not admissible in a trial in this case.
Okay. And we don't need to focus so much on she broke the law and is guilty of a crime as, is it excludable or not?
I understand. I just
Okay.
wanted you to ask the question. I just
No,
want to
no,
make sure you
I got
understand
it.
my position.
Okay. Ms. Nix, it looks like you're ready to go forward with the motor vehicle stop. I don't know why I assumed that the detective is here for that versus the other. Are you also in a position to go forward with the 16-11-62 challenge, the Ms. Ramirez challenge?
Judge, Mr. Ramirez is here. I am not planning on calling any witnesses for that. I just have argument.
Okay. You think just based on the record that exists, you're in a position to lay out why things shouldn't be excluded?
Well, I can call Miss, if this is kind of because it's styled as a motion in limine, I would assume that the defense would go first.
Well, let's do this. Let's table that one. We'll talk about it today because we've got everyone here, but let's start. We've got the detective here. Let's tackle the traffic stop case. And then you can let me know your thoughts, but you're right. I mean, it's style of motion in limine, but ultimately, if you're the proponent of the evidence, you'd need to explain how it comes in, but the person seeking to exclude it is the defense. So I'd hear from Mr. Willis first, and then we'll see, is this just something that the lawyers can handle, or do we need to bring Ms. Ramirez in? I just assume not, if that's a delicate situation. She's gonna have to testify at trial anyway. But if I do need to hear from her to make a meaningful ruling on Mr. Willis's motion, it sounds like she is available. Okay, great.
Your Honor, we also have an immunity motion filed in that case.
Yeah, I thought you did. And
Prepared to go forward on that today also.
okay, if we've got time, we will. If not, that'll be part 2 of when we get together. Those can take 2 days. Those can take 5 minutes, and you can see what time it is. I want to get through the traffic stop, and then we need to talk about the alleged privacy violation, and then let's take stock of what's left. And you may be able to preview, and that's one where you would be calling the witnesses. It's your immunity motion. So you'd be letting me know, look, it's going to be 7 witnesses. And I'll say, all right, that'll need to be another day. But I haven't forgotten about that. I flagged it yesterday, and we'll figure that one out. Okay.
Your Honor, Ms. Ramirez is here under my subpoena, by the way.
Okay.
Just so.
Right, your 9 a.m. subpoena.
Correct.
Right.
Well, that was, I think we delivered it to her before we got the 2 p.m. notice, I think, but.
It's okay. We managed it. All right. Then why don't do you feel, Ms. Nix, like you understand the contours of Mr. Willis's arguments concerning the traffic stop? And I ask that not because you don't know how to read, but sometimes it's helpful for the defense attorney to say, look, the issue was they used a dog and they didn't have probable cause to use a dog. I just don't want us to go in circles we don't need to go in. And Mr. Willis has already said, they prolonged the stop and this and that. And so I just want to make sure you know what you need to be defending, the police actions that you need to be defending.
I think I understand.
Great. Then let's go forward.
Is it Sergeant or Detective? Okay, so we'll call Detective Wells.
And Your Honor, I am going to invoke the rule. I don't see any other witnesses. I just want to make sure it's invoked.
Great. If you've got anyone else who would be testifying about the same kinds of things that the detective will be testifying, they should stay outside. And I'll let you know on the Zoom call, there's no one I don't know. So we're good.
Thank you, Your Honor.
Sure.
Do you swear or affirm that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth, so you know?
I do.
Okay, well, we have a seat for you. State and spell your name for the record as well.
Detective Michael Wells, M-I-C-H-A-E-L, last name W-E-L-L-S.
Detective, can you move the microphone bends some? It doesn't move at its base, but there you go. As long as it's, yep. I can hear you just fine, but our court reporter is far, far away and she needs to be able to hear you. Thank you. Ready.
Thank you, Judge. Detective Wells, where are you employed?
With the Roswell Police Department
How long have you been with Roswell Police Department?
since June of 21.
And what is your job there?
Currently, it's with the Crime Suppression Unit.
Are you a post-certified law enforcement officer?
I am, yes,
How long have you been a post-certified law enforcement officer?
since August of 21.
Were you working in that capacity as a law enforcement officer on August 8th of 2023?
I was.
Whereabouts were you working? What area of Roswell?
It's an area in which we call the corridor. It encompasses Holcomb Bridge Road and Old Dogwood Road.
Around.
Why is it called the corridor?
It's right there by Georgia 400, and the corridor is a place we frequently have most of our traffic stops and crime that happen in the city of Roswell.
Okay.
Did you conduct a traffic stop on a white Mercedes-Benz around 13:45 hours that day?
Yes, I did.
Tell the court why you conducted a traffic stop.
So on August the 8th, at that time, myself and my partner, Detective Sean Bath, first name SHAUN, last name BATH, observed the white Mercedes traveling down.
Hold on one second.
Not about what someone else has observed.
Okay, so you should talk about what you observed. I was about to ask, is Detective Bath sitting right next to you, or he's in a different car? Sean's a guy?
He is.
Okay.
Detective Bath is my partner. We operate on the same team.
Okay, but are you in different cars
We're
or?
in different vehicles, yes.
All right, so to Mr. Willis's point, you don't know exactly what Bath is seeing because he's not.
Yes, Your Honor.
And you know that because?
We communicate over the PA system within our vehicles.
Okay, well, let's start with what you saw and what you did. And then if Ms. Nix wants to know, well, what did Bath do next? Then that'll give Mr. Willis a chance to know, well, now maybe I'm going to object because of X or Y or Z. Certainly, if you saw it, you heard it, you did it. Hoping there are not a lot of objections about that, but we'll hear.
So on that day, I observed Detective Bath initiating a traffic stop on the white Mercedes heading on Holcomb Bridge Road. I immediately pulled behind Detective Bath, followed him as he's initiating the traffic stop. The traffic stop ended at 1100 Holcomb Bridge Road, which is at the Shell gas station. Once I got out of my vehicle, Detective Bath was already at the window talking with the defendant, Mr. Carter.
Reason for the traffic stop.
The reason for the traffic stop was.
Objection, Your Honor, it's going to be hearsay.
He can testify if he knows.
Sorry, excuse me.
Hold on, what, both of you stop? Yes?
Ms. Nix, can you please go to the podium? I'm having trouble hearing you.
Sorry, the microphone wasn't on.
All right, so we'll try it again. I don't mind you there as long as the microphone's on. So let's try that. I'm going to overrule the objection at this point. What is your understanding of the basis for the traffic stop?
That the vehicle's
I
heard you object, and I overruled.
Two cases that are directly on point. Kazim and Burrell are directly on point as to an officer explaining the reasons of another officer talking to someone, detaining someone, stopping someone. So there are cases directly on point on this issue. I just want to make sure the court's clear on that.
Got it. What was the basis for the traffic stop?
An expired tag.
Okay, an expired tag, if I'm understanding correctly, it would have a March 22 sticker, and here we are in August 23.
Correct. His tag had been expired since November of 22.
Okay. Did you at any point during the traffic stop look at the tag yourself, or?
It was observed as we walked up to the vehicle.
I
walked up to the vehicle.
Okay.
Yes, Sean.
All right. Keep going.
Thank you, Judge. So you observed the tag on the back of this white Mercedes.
That is correct.
All right. Do you remember what the registration date was on it?
The registration date expired as of November 22.
Okay. What did you do next?
So I approached the passenger side of the vehicle. At that time, the passenger side window was rolled up, but I could smell the odor of marijuana coming from the vehicle even as I was approaching. I observed Detective Bath speaking to the defendant, Mr. Carter, explaining the reasoning for the stop, why it was being stopped, and then shortly after asking him to step out of the vehicle.
Now let's talk about the odor of marijuana. Have you had the opportunity, either in your job or in your life, to smell marijuana?
Yes, I have.
When you have smelled marijuana, have you been given the opportunity to observe the odor and then have it test positive for marijuana?
Can you ask it a different way?
I'm asking you to testify as to whether you've observed the odor of marijuana that then was confirmed to be marijuana.
Judge, I'm going to object as far as the testimony about what a scientist has done in a lab. It's going to be hearsay. And also this officer does not have the proper training. There's no foundation for it. And of course, there's a requirement under Daubert that there be a scientific foundation laid for any sort of scientific testimony.
Okay. So I'm not finding that recognizing the odor of marijuana, burnt or raw, requires scientific expertise. So I'm going to allow the officer to talk about his experience with smelling burnt or raw marijuana. But what do you say, Ms. Nix, about the hearsay objection? I don't know how this was going to unfold, but what Mr. Willis was forecasting is that the way that Detective Wells would know, I smelled what I thought was marijuana, and it was later confirmed to be marijuana because it was sent to the crime lab and someone told me, i.e. hearsay, yep, that's really marijuana.
I'll just move on, Judge.
Okay.
I think he has the ability as a law enforcement officer or as a layperson to explain that he knows what marijuana smells like.
Okay.
All right. So you observed the odor of marijuana, you stated, and then what happened?
So then the defendant, Mr. Carter, was asked to step out of the car, which he complied. Once he stepped out of the car, he came to the front of Detective Bath's vehicle. Detective Bath explained to him at that time that he could smell the odor of marijuana coming from the vehicle. I stood by as he was explaining this. He was going to do the search on the vehicle while I sat and talked to the defendant, Mr. Carter. He told Detective Bath at that time that I was smoking last night, but it was evident that the smell was coming from the vehicle.
Okay. Was he under arrest at that time?
No, he was not.
Was he in handcuffs?
He was not.
Was he in the back of a patrol vehicle?
He was not.
Was he told that he was detained or not free to leave in any way?
No, he was not.
Okay.
Was he though at that moment? If Mr. Carter had said, "This is fascinating, but I'm gonna go take an Uber," was he free to go?
No, he was not. So I will rephrase. He was detained at that time due to the traffic stop. And because at that time we had already smelled the odor of marijuana, giving us reasonable suspicion to believe that there was marijuana within the vehicle.
So I guess what I'm asking you is, at that point, was the vehicle detained or was Mr. Carter detained?
It was a traffic stop. The vehicle was not free to leave, nor was Mr. Carter free to leave.
Okay. So did you tell him he was not free to leave?
I did not.
Okay. How was this conversation happening? Where were you positioned? Where was he positioned?
He was standing in front of Detective Bass' vehicle. I was standing next to the white Mercedes. We were in between the two vehicles having this conversation.
Okay.
And this is all in the Shell station parking lot?
Correct.
What did the two of you or whoever was on scene talk about?
Myself and the defendant, Mr. Carter, had a conversation about his recent citation from DeKalb County for the expired tag. He was aware that it was expired. He just hadn't gotten it corrected.
You said from which county? I'm sorry.
DeKalb County.
DeKalb.
I was verifying his information, his current residence, his address, asking about the marijuana. I asked, did you smoke last night? Because he had expressed to Officer Bath that he had been with some friends that were smoking, but then once he said he had smoked, then he said he hadn't, then he said he had again. So it was kind of back and forth. And then he made the statement, as soon as y'all pulled me over, I knew the car smelled like marijuana. Shortly after that, Detective Bath had gone back to his vehicle. I've spent a lot of time with Detective Bath. I know some of the manifestations he gives when he finds things in a vehicle. Another officer was present standing with the defendant, so I went to go talk to Detective Bath, and at that time he showed me he had
Who's the third officer?
Canine Officer Peter McDonald, first name common spelling, last name MacDonald, ALD.
All right.
He's one of our K-9 officers.
Was the dog in the car or out at this time?
He was inside of the patrol vehicle.
Oh, dog and McDonald or just dog?
Inside the patrol vehicle, just the dog.
Got it. McDonald is out and talking with you.
The dog never got out on this traffic stop.
Good.
So he stayed with the defendant while I went and talked to Detective Bath on what he had found inside the vehicle. And he showed me a blue oval pill that had an imprint on it. And typically when we find pills such as that, we go to pill identifier online, put in the imprint and see what exactly it is. In this particular case, the blue oval pill had the imprint Bravo 706, which returned alprazolam.
Judge, I'm gonna object, lack of foundation and also hearsay and also a dauber. There's no foundation for scientific testimony.
Okay, so to be clear, I'm not concluding from Detective Wells's testimony that it was in fact alprazolam, but I do think that their research might, we'll see where it goes, explain whatever it is they did next. But this wouldn't be anything that would be admissible in front of a jury to prove that it was that as opposed to a piece of candy. So keep going.
When you say Bravo and then some numbers, do you actually mean Bravo, like the word Bravo, or is it a B?
A B.
Okay. Did you advise Mr. Carter about what you had found or what officers had found on scene?
At that specific time or later in the stop?
Later, at any time?
Yes, we did.
Okay. Did he appear to understand what you were saying?
He did. He didn't believe that we had truly found it in the vehicle. He said that it was not his and that we had planted the evidence in the vehicle.
How old would you estimate the defendant to be on the date of the offense?
32, I believe.
Are you estimating or based on the date of birth or driver's license?
I would say based on the date of birth.
Okay.
Did you discuss his education at all?
I did not.
Did he appear to be intoxicated or otherwise incapacitated?
No, he did not.
Did you promise him anything in exchange for agreeing to speak with you?
I did not.
Did you threaten him to get him to speak with you?
I did not.
Were you the person who had the primary interviewer of Mr. Carter?
Yes, I was.
I see you're wearing a body camera today. Were you wearing that camera on August 8th of 2023?
Yes, I was.
Was it in proper working order?
Yes.
How does your agency use body cams?
It is our policy to have them on at any incident that we are involved in, whether traffic stops or regular calls of service. We are to have them on and uploaded during our shift.
Is it the type of body cam where it is always recording and always saving, or do you have to turn it on and off at each interaction?
It is automatic in some situations. When our blue lights are activated in our car, the body cameras are automatically turned on. If blue lights are not, we have to manually turn them on.
Do you know in this case if your body camera was activated?
It was.
Do you know if you turned it on or if you turning on your blue lights is the reason it turned itself on?
I cannot recall exactly which one.
Okay, but one of the two happened, you believe?
Correct,
Okay.
yes.
When a video is created with the body cam, how is it saved and uploaded?
So we dock our cameras on a docking station. At that time, it uploads all the videos from that day or during your shift. And then it goes into evidence.com where we can go and review cameras specifically related to our cases.
And how do you know that a video that was taken is related to one of your cases and not just that it was your body cam, but how is it associated with a particular incident?
By case number.
How do you do that? How does the system do that?
from my understanding, in our office, there are admin personnel that attach our body camera files to the particular case numbers. It is not something that we do on the patrol side of things.
Can the recording be edited or deleted while you're wearing the camera?
No.
Are there safeguards to prevent tampering with the recording while you're wearing it? While you're wearing the body cam, excuse me.
We do not have the ability to do anything to the video other than to tag the video with category like felony, misdemeanor, traffic stop, those such things.
Were all of the policies and procedures that you mentioned followed for the video recording in relation to Roswell PD case number 2308-000334, which is the one we're here for today?
Yes.
While it is being, actually, I'm just gonna, may I approach the witness, Your Honor?
You may. Both of you have the ability to approach witnesses.
Showing you what's been marked as State's Exhibit 1, do you recognize this?
Yes.
What is it?
It is a CD disc with my body camera footage on it.
How do you know that's what it is?
I was able to view it.
Is this your initials here on the sleeve of the?
Yes, it is.
Has the video on this just been altered or omitted in any way?
It has not.
Does it fairly accurately reflect what you observed on the date of this incident?
Yes.
State moves to admit State's Exhibit 1.
Mr. Willis, any objection to States 1?
Your Honor, no objection for the limited purpose of this hearing, but I am going to tell the court there's a lot of hearsay on this video that would not be admissible at this hearing or in the trial, Your Honor.
Okay, so two things. One, certainly it's only admitted for purposes of this hearing. Whether it goes beyond that, TBD. And then two, I guess we can work through the hearsay. It's an actual recording of what happened. So I don't know that that's a hearsay issue so much as here's a recordation of what occurred. But I'll admit States 1.
Thank you, Your Honor.
Judge, usually I put it on the Zoom.
Yep.
Is that how you'd like me to do it?
Yeah, and just make sure when you do screen share, you click those two little boxes in the lower left-hand corner. That should make it most likely to be audible for all of us. While Ms. Nix is working on getting that up, Detective Wells, did you at any point during your interactions with Mr. Carter Mirandize him?
I did not, no, sir.
So all the exchanges would be investigative exchanges, biographical, just chatting, but they were never the product of you've got the following rights, you want to waive them and talk to me. Is that a fair statement?
I did not read him Miranda, Your Honor.
Okay, you did not. Did Bath do it in your presence?
He did not. At the time of our conversation, he was not under arrest.
Okay, I'm just asking whether you Mirandized him or not. You didn't, Bath didn't, as far as you know, and McDonald didn't.
No, Your Honor.
Okay. So I won't make you pause it because he's still driving, but this is 50 minutes long. Are you playing the full 50 minutes or do you want to jump to a point or you're at the point where you want to be because there's the Shell station?
Yeah, it's getting.
Tell you what, just so I don't have to coming back and forth and everything, okay? I just had to step back with me, I can give you information. I'm not gonna give you another thing, okay? You don't do the other, all right? Okay, all right.
I think there is one in my glove compartment. I can't remember.
Okay, that's Georgia. Just come back here, Mr. All right. Yeah, like I said, you already got a ticket, okay? Car reeks of marijuana. What's going on?
You can say
No, I'm objecting to that hearsay. Clearly, that's another person out of court making statement.
Okay.
It's on you, on your person.
You keep playing it.
Nah.
Okay.
I was smoking last night.
Were you?
Yeah, I was out.
All right.
But there's literally no weed in there, so.
Okay. Hey, look. As long as the vehicle smells like that and you get pulled over, this is just what you're going to be dealing with.
I understand.
I'll search the vehicle and then I'll have you on your way.
Okay, that's fine.
Okay.
I'm just gonna verify the rest of your information while he's doing that, okay?
All right.
So you just got a ticket?
Yeah, literally, yesterday.
For the, expired tag?
I didn't even know it was expired. I just got my license back, so I haven't even been driving the vehicle, so I didn't even know it was expired.
When did it expire? Was it last
it's
year?
on my birthday. Yeah, of last year. That's why I was confused, because I was wondering.
Can you pause it for a second?
Where'd you get this at?
So you're holding a DeKalb ticket. This is what you were talking about. You said you had a discussion with Mr. Carter about a DeKalb citation. Right. I was under the misapprehension that you'd run his name and something popped up in the system. But in the Mercedes-Benz was the ticket that Mr. Carter had received for driving this car in DeKalb County with an expired tag.
That is correct.
Okay. Do you recall the date of the citation?
No, Your Honor.
Okay. I mean, it had to have been before you encountered him, but you don't know if it was a month ago and he'd been driving for a month with that knowledge, or if it was earlier that day.
That is correct.
Okay.
In DeKalb?
DeKalb.
Okay. 185.
And this is your current address and everything on here? Yes, okay. All right, so you smoked last night?
I wasn't smoking, but I was with people, and yeah, we were smoking. Yeah. They were smoking.
You smoke too, though, didn't you?
Oh, I do smoke.
Okay.
I'm not gonna lie.
It smells like that. I know you smoke in that car. All right. But if it's just a little bit, we're not really concerned about that.
There's none in there. Literally. As soon as y'all pulled me over, I was like, damn, my car probably smells like weed.
Yeah.
But I don't have anything in there.
I got you. When's where are you coming from?
Seeing a friend.
Where at?
At the hotel right over there.
Okay. Do you know which one?
I'm not sure what it's called. It was right by that light though.
Oh, okay.
Yeah.
Who's your friend?
Crystal.
What kind of weapon do you have? Is it a firearm or
yeah,
knife?
it's a firearm. I'm pretty sure. If it's in the, I haven't checked, but if it's in the glove compartment, it's a 9mm.
Okay.
I can't remember if I left it in there.
I appreciate you letting us know.
Yeah, I can't remember if I left it in there or in the crib.
Okay. What happened to your hand, man?
I was in a bad car accident when I was younger. My hand, my chest, whole side of my face. Well, I got hit by the car. Flew up in the air, came down on my head.
Golly.
In front of the car. So the car hit me again, and I got caught under the tire and dragged for like 200 yards. I mean, about 200 yards. So that's how I got the burns.
Yeah.
Nice. Sure.
How old were you?
Like 8 years old, 9 years old.
Okay. That's young, man, to be in an accident like that.
Yeah.
You still have like nerve damage and stuff?
Nah.
Not too bad?
Nah, I don't have any damage.
I got you.
If that would have happened like today, though, definitely probably would have died.
Yeah.
But you know, when you're young, you can handle things a lot better.
Yeah. Unfortunately, we see a lot of people that get in accidents. It's not their fault. We had one just the other day, right down the road here. 21 years old, died. DUI driver. He lived.
Oh, for real?
Yep.
It was a DUI case?
Yep. It's unfortunate, but we see.
Oh, the DUI driver lived?
The DUI driver lived. A 21-year-old died. Yeah. So, all right, you don't have any weapons or anything in your pockets?
Nope.
Okay. I'm gonna pat you down for weapons. All right. Do you mind if I search your pockets?
Yeah.
All right. So look, turn around and interlock your fingers like this. No, behind your back. Sorry. You good? I'm not putting cuffs on. Okay. This is just me grabbing your hands. Was this just your phone?
Yep, phone.
All right. Another phone. Now, a lot of people carry 2 phones these days. Can you spread your legs for me?
One of them doesn't. But I got contacts in there.
The AirPods?
Probably.
Yeah. All kinds of pockets, man.
Yeah, I know, right?
Oh, it's just your wallet. Gotta keep up. Alright, man. You can relax. Just got a tattoo of Linda?
Yeah, that's my mom. I only got my family's name. It's my sister.
That's nice. I like seeing people's different art, man. Everybody's got a story to tell with their stuff. So.
Yeah. Yeah, no, I just got, I don't know, my first tattoo is this one, because
what was that?
My dad's name. My dad, he was against it, so I was like, no.
See, my first tattoo is going to be my dad's name.
Exactly. You can't be too mad.
I hear you. All right. What's the shirt?
I have no clue, to be honest with you. I just like the way the collar fits my neck.
It looks like it's French.
Yeah, I don't know what it means, to be honest with you. I don't know.
Well, what you do for a living?
I do real estate.
Do you?
Yeah, with my peoples. It's a family business.
Okay. Man, a lot of
Been
people
doing
do
it for
real
about 8
estate
years
do
now.
pretty good.
Yeah, I mean, we've been doing it for a minute now, so.
Yeah. Properties around here are so expensive, man.
Mm-hmm. Why do you take my gun?
Huh?
I said, why?
So they're just going to secure it until we're done with everything, and we'll put it back in the car.
Oh,
it's just a safety thing that we do.
Okay.
Like I said, I appreciate you telling us you had it. A lot of times, what makes it even more sketchy is when we ask people, do you have any firearms? They say no, and then we go in the car and we find 3. You know, because then it's like, okay, there's something more to all this. So it's just a safety thing that we do. You know, if we get into a fight or something, they run to the car, try to grab it. You see what I'm saying? So what we do is we secure it, and then once we're done with the search and everything, we'll put it back in the car. I mean, it's not illegal for you to have a firearm. Where do you mostly do real estate at?
All over, really. Wherever the best deals. That's why I'm looking for the best deals, you know. But I mean, I've had properties all over.
Yeah. How long you been doing that?
I told you about 8 years.
8 years?
Yeah.
8 years. You like it?
Yeah. Yeah, it's good money. It just takes a little time.
Yeah.
You know what I mean?
That's what I hear with real estate. You gotta work, get your name out there, and
no, I'm saying like the return.
Oh, get a return?
Yeah. But
you got anything other than real estate that you do?
I do trucking.
Really?
Yeah, I got a couple trucks, but real estate is where I make
like
the boat.
You truck or you send the trucks out?
Oh no, I'm not driving them. No, I got drivers.
I got
and stuff.
you.
Yeah.
Some of my family does trucking, so I didn't know which side of it you were on.
Yeah, nah, I'm not driving.
You the smart one. You have the truck, send it out.
Yeah. I mean, if you drive, you make more money for sure, but you know.
That's a hard life, though.
Exactly. You're on the road 24/7.
Yep, that is a hard life. you on probation for, brother?
Say what?
What are you on probation for?
Tough. I can't see.
Looks like 8705.
8705.
Yeah.
Not a big.
No, it's an 8. No.
706.
It may be B. Hold on a second. No, it is a B. It is B705. Xanax. Where you find that on the floor? What about the firearm?
On the driver's side seat. Pete's got it running right now. Pete's running it, and then Pete's running it and a CH. Okay. And as well, because I did find some leaves anyway.
You did find marijuana there?
Huh?
How much? Or just shake?
Just, yeah.
All right. You got a bag back there? You got a bunch of leaves back here, dude. Is that the marijuana?
Yeah.
He's on probation. I can't imagine he can have a firearm. But I don't know the terms of his probation.
It's gonna be the marijuana. You got a knife?
Yeah. Ready? Well, one's enough.
Well, you taking this one?
Huh?
Are you taking this one? Lift up. Go ahead and secure him.
Yeah. What size glove do you have?
Extra glove.
I don't like the way these stick to everything.
Yeah, the second your hands get wet or sweaty.
These are hard to put on.
This one?
He's shaking like a leaf, man. I thought y'all were gonna find more than just that one.
It's gonna be on him.
Yeah.
Where's McDonald during all this?
At this time, Your Honor, he's talking to the defendant
Okay, and where are they? Because,
at the front of the vehicle.
okay. Basically, between the white car and Bath's car. We just can't see them.
I'm just gonna go ahead with the speech about checking his person or whatever. As soon as I get him turned around, we're cuffing, okay?
Okay.
What's his last name?
Carter.
Carter. You found a little bit of blood in there, okay? There's just a little bit of weed.
That's what he told me.
Yeah. Talk to your person now, see if there's any weed on you, okay? All I need you to do is turn around for me.
Place your hand behind your back. Just interlace your fingers like that right there. Cuffing me? Yes, sir. Sir. What am I getting arrested for? You also got Xanax laying in the back seat of your vehicle. Yes, sir. He's a pretty broad-shouldered guy. Go with the 2 cuffs. Got it? Yeah. Can I see the Xanax? Yes, sir.
I'll do these so they don't pinch
That
down.
one's a little tight on it.
Yep. Those are smaller cups.
So is there much that happens, and now he's in custody, so unless they're gonna interview him, is there anything after this that you'd be using at trial?
I wouldn't expect to. There are some, I guess, questions that the defendant is asking and the officers are answering, but there's not really anything.
Okay, but if he's asking, that's not anything solicited or elicited by the officers. I've heard Detective Wells say, we didn't Mirandize him. So we'll have a discussion about some of the questions they asked during the interaction while Bath was searching the car. But what you're representing, and this is in evidence, I can watch it if you all need me to, but he's clearly under arrest now. It doesn't sound like there's more investigative questioning by Bath or Wells or McDonald after this. If Mr. Carter had some investigative questions, that comes in. Those are things he's asking, and if the answers are relevant, they come into.
Yes, and I reviewed the video, and so I don't believe that there's anything else after that. But if it was a question asked by officers that was not, biographical information, things like that.
Does this hurt your wrist? Hey, duck your head. We're getting you in
I
the
think
car.
they asked him about, what do you want us to do with your phone and the money that they found in his pocket. I don't think there are any other things that are the defendant responding to a question other than that. So I don't believe.
Okay, and to be clear, Mr. Willis, you're free if you want to, when you're asking questions, jump to minute 45, we can do that. There's a bunch of minutes left, and if it is mostly your client sitting in the back of a patrol car, we don't advance your arguments much with that.
I've got a better one than that even. I think that the state and I can address any statements after this point in the videotape, and if we can't come to an agreement, if you wouldn't mind just indulging us with a short hearing on that.
Sure.
I can't imagine us spending more than 15 minutes on it.
Okay,
at this point.
works for me.
Thank you.
Great. All right, so do you have, now the video's done for this witness, do you have other questions for Detective Wells?
How long were you on scene between when the stop was made and when the defendant was placed under arrest?
Approximately 20 minutes.
Okay. Did this occur in Fulton County?
Yes, it did.
Okay. Nothing further, subject to redirect.
All right, Mr. Willis?
Thank you, Your Honor. Detective Wells, I'm Greg Willis. How you doing, sir?
Hey, doing good.
I got some questions for you.
Okay.
If you don't understand my question, can't hear me, can't understand what I'm trying to get to, please just let me know and I'll try and clarify.
Okay.
You mentioned a fourth officer on the scene. I think you called him Lieutenant or LT. I can't remember what you said.
Beyond myself, Bath, and McDonald?
Correct.
Later in the videos, my sergeant shows up.
Sergeant, I'm sorry. Did I hear you say LT or?
I hadn't mentioned it yet today. It may have been in the video.
Okay. And who was that sergeant?
Sergeant David McNamara, McNamara.
Okay. And on direct, your testimony was that the imprint on that pill was B706, correct?
Say that again. I'm sorry.
On direct, your testimony was that the imprint on the actual pill was B706, correct?
Correct.
And we heard on videotape at least 3 times where you gave the number. I know you changed from an 8 to a B, but you gave the number at 705 at least 3 times, correct?
I don't know how many times, but yes, that's correct.
Well, did you ever hear 706 on the video that we just heard?
So you want to compare my My video statement to my incident report.
I'm not asking you to ask me questions. I'm asking you a specific question. So if you don't understand my question, let me know, but don't ask me questions. The question I have is, do you hear on the video anywhere where you said the number 706 consistent with your earlier testimony?
No.
Okay. So everything we heard on videotape was 705. Is that fair?
That's fair.
Okay. And you talked about a safety thing with the gun. Would you agree that someone took possession of that gun and also ran the serial numbers on that gun that day?
Yes, they did.
Okay. And I think your testimony, just so I'm clear, was that the defendant did not show you any indications whatsoever of being under the influence at that time, correct?
That's correct.
So you didn't think he was impaired by drugs or alcohol?
I did not.
Okay. And just so we're clear, the only reason he was charged with a pill that was found behind his seat or in the back of the car somewhere was because its location in the vehicle. Is that fair?
It was located in the vehicle. Yes, sir.
Okay. But I'm saying, is there any, I'm trying to get to, is there any other correlation evidence you have that would indicate that that pill belonged to Mr. Carter, or he was knowledgeable of that pill being in his car?
Judge, I object to this. We're getting outside the issue of the defendant's motion, which is the stop, the search, and the statements.
Okay.
Probable cause, Your Honor.
We have already, this is past probable cause. They've already searched the vehicle. You can't get probable cause after.
Well, I'm going to let him explore it because it's early on in the questioning, but if we're getting into constructive possession and this, that may be a jury question eventually, but we've got a car, he's driving. My understanding of the law is things found in that car at the scene are properly attributable to Mr. Carter. Now, he may trot in a witness or an affidavit long past the arrest after he's hired you saying, hey, here's my prescription for alprazolam, and I was missing a pill and I was riding in the backseat of his car. Oh, okay, maybe this isn't a case that needs to go to trial. But for the officers responding on the scene, they didn't find it on the sidewalk outside the car. As I heard the testimony, it was on the back seat of the car, of which the only occupant and sole driver was Mr. Carter. So keep going, but if it's getting into, hey, that could have been anyone's pill, they have probable cause to believe it's his pill because it's his car and everything in that car is attributable to him, at least initially.
I understand, Your Honor. I'm not asking about constructive possession. Right?
Okay.
So Officer Wells, I'm back to my Detective Wells. I apologize. I don't mean to.
That's all right. I understand.
An officer detective. I apologize. So there is no evidence that you can tell us today, other than the pill being in the vehicle, that would attribute it to be belonging to Mr. Carter. Is that fair?
Yes.
Okay. And every time you discussed it with him, he denied knowledge of that pill, correct?
Yes.
And is that something that would have, I don't recall there being much discussion of, other than he sounded surprised when you guys said there was a Xanax in there or something. Because you had mentioned on direct, yeah, he claimed we planted it, but I didn't hear that, but it was kind of hard to hear. Or is that something that would have happened later on when he's asking questions? Like, what's this about? I mean,
so Your Honor, the defendant had asked for if we would show him what was found within the vehicle.
Right. I heard him say that.
We obliged and we showed him what was found in the vehicle. And at that time, he was already in the back of my patrol vehicle.
Got it. So we're fast forwarding a few minutes on the video. Okay.
Yes, Your Honor.
Yes, I heard that after the arrest, Your Honor.
Okay.
So when you were standing there, well, first of all, did he admit that he thought the gun was in the vehicle? He told you that was there, correct?
He said he believed it was in the glove box.
Correct. So he admitted that.
Mm-hmm.
And just so I'm clear on the videotape, you did not stop Mr. Carter. You did not put the blue lights on him. Am I correct on that?
That is correct.
Okay. And as I see you get out of your vehicle when you're at the scene, I don't see any markings saying Roswell police or police anywhere on the stopping vehicle. Is that fair?
That is not accurate.
Okay. Tell me what I'm missing.
So our particular vehicles with the crime suppression unit have what we call ghost letters. It does say Roswell Police Department on the side of the vehicle. It's on both the driver's side, passenger side, and the rear. But we do not have lights, blue lights that are exposed on top. They're all interior, and our ghost lettering on the side is not reflective.
But it's not black on black, is it?
It's ghost lettering.
Okay, but ghost lettering to me says it's invisible, in which case it's like it's not there. So
I guess ghost lettering is what is typically referred to as it's a very dark gray.
okay. If you were standing in bright daylight next to your SUV, you could see it, or would you have to get secret blue light device?
You could see it if you were standing next to the vehicle.
Okay, but if I'm just driving along and then there's this black SUV behind me, there'll be blue lights that you'd see. I could see them there, but it's not your standard deck of lights, white car with blue doors or something like that.
That is correct, Your Honor.
Okay.
And just so we're clear about that question, the blue lights would not be visible unless they were on. Is that fair?
The blue lights are only visible when they're activated.
Correct. So they're inside the vehicle, not like a bar on top.
That is correct.
Okay. So I'll rewind that to where he gets out of the vehicle.
He gets out of the vehicle?
Correct. Right there. Now, Detective, I'm gonna get you to the beginning of this videotape, and I want you to look at the back of this car. You just said these vehicles have markings on the rear of them. I want you to point out where they are on the rear of the stopping vehicle's car.
$716 or $714.
I can't see the bottom of my screen. Could you rewind it just a little bit more?
Oh, I can see it though. It says police, but it's down, it's below the license
Down,
plate.
yes.
And it says Roswell Police.
Yes.
Boy, it is ghosty, but it's there. And then the on the back's not gonna help someone who's being pulled over from the front, but
Right.
it's there. Okay.
Can we go back to the shot he asked for, the officer asked for?
Just press play from there. Nope. So if you pause it right there, you can't see it from there. But when he was closer, you could see the word police. And
Yeah, so the Roswell Police is underneath the handle below the license plate.
Underneath the handle. Now, when you say ghost lettering, you're talking about some serious, difficult to see lettering, correct?
It is. It's designed that way.
Okay.
Because of our particular unit.
Okay, and you're not a traffic unit.
I am not a traffic unit.
Okay. And you're, I guess, is Bath your boss? Supervisor?
He is not.
He's an equal?
Yes, sir.
Okay, so with Detective Bath, is he in the traffic unit?
He is not. We're part of a crime suppression unit. Everyone on scene is part of the same unit.
McDonald is part of CSU also.
Yes, Your Honor.
He's the canine part of CSU.
Yes, Your Honor.
Detective Wells, have you had any training as it relates to hemp and marijuana and cannabis plants?
Have I had
any training?
Yes, Your Honor. Not Your Honor. Yes, I have.
I am definitely not a judge, as much as I'd like to be one. You have had training and you've learned that the same exact plant produces marijuana and hemp, correct?
Correct.
And that the only difference in those two plants is not the species, but the amount of marijuana or THC, active THC in those. Is that fair?
Judge, I object I think we are actually getting into scientific things. And so this officer is not an expert, and this is past what a normal person could testify to.
Okay, but we're talking about his training, but I'm mindful that it was in fact Mr. Willis who said, hey, let's not get too scientific with this non-scientific expert. So I'm gonna let him explore this a little bit more, and we'll see where it goes.
Thank you, Your Honor. So my question is, you're aware that it's the exact same species of plant that will produce illegal marijuana and legal hemp. Is that correct on your training?
That is correct.
Okay. And your training, of course, did they smell the same way because they're the same plant?
That is correct.
Can I have 1 second, Your Honor? Talk to
You
my
can,
client?
sure.
That's all I have. Thank you, Detective.
Thank you.
Do you have any redirect, Ms. Nix?
No, sir.
All right. Detective Wells, thank you for your time. Appreciate it.
All right, thank you.
Have a good weekend. Do you have any other witnesses to call, Ms. Nix, in connection with the motion to suppress evidence and statements? I have a question before you, Detective, before you leave the room. You're still under oath. Just speak loudly or get near a microphone. The extent of what was seized from Mr. Carter's car vehicle was one pill, the blue pill, a trace amount of marijuana. That's what was going in the finger of the glove, and a firearm. Anything else?
No, Your Honor.
Okay, thank you. All right, Ms. Nix, any other witnesses in connection with the suppression motions in the traffic stop case?
No, sir.
All right, any evidence you want to put on, Mr. Willis, in connection with the suppression motions in the traffic stop case?
Yes, Your Honor. I'm gonna call Mr. Frederick Whitehurst to the stand.
Okay. He's someone who's outside?
He is.
Okay.
Can you grab Mr. Whitehurst, please? Thank you.
Testimony you will give to the motion. What truth you have got.
I do.
Go ahead and have a seat. Please spell your name for the record.
My name is Frederick Whitehurst, spelled Whitehurst.
Mr. Whitehurst,
Before we get started, I object to this witness testifying as irrelevant. I believe that his testimony will be that the odor of marijuana and the odor of hemp are the same, which the officer already admitted they smell the same. This is not useful in this question of whether the search of this vehicle was based on the auto exception and probable cause, because courts have ruled that it does not matter if that hemp is legal. If officers smell marijuana, that is probable cause for a search.
Right. How would this be different, Mr. Willis, if The officers were familiar with Mr. Carter. They knew he was a felon. They saw him driving with what looked like a gun in his car. And so they stop him, they get him, they arrest him, and it turns out that that gun is a replica. It's not an actual gun, but they had probable cause to believe there's a felon in possession of a firearm. Later investigation clears it up, but the arrest is the arrest. Later investigation shows that pill's not alprazolam. If it's not, then a felony didn't occur. There goes the charge, possession of a firearm during commission of a felony, et cetera. But this potential, and here you'll be speculating that it was hemp rather than marijuana, although we have your client saying, yes, my car smelled like marijuana and I had been smoking marijuana, not hemp. But how does this possibility that it could have been hemp differ from the real gun, fake gun, still probable cause based on what the officers reasonably perceived to be accurate?
Well, my client said weed, Your Honor. He never said.
Fair enough. He said weed.
Just so the record's really clear.
Okay.
Your Honor, we're trying to create a record, and this is being done all over the United States, just so the court understands. The courts have moved away from giving officers probable cause based on the odor of hemp or marijuana because of the federal hemp bill, which has been adopted in most states. So we're now getting something that used to be before 2019 in Georgia, clearly would indicate something illegal is going on in the car now. But we're beyond that. We're not in 2018. We're in 2023 when this happened. And the reality is that it is insufficient to get someone out of the car just based on something they perceive to be what could be marijuana or could be hemp.
Is there case law to support your theory, or you are hoping to be in the vanguard to get an appellate court to some point say it's not enough because hemp is not illegal to possess, and so that wouldn't be a sufficient basis to search the car?
We are in the position, Your Honor, that we're trying to create a better record than we've ever had in Georgia. And in my opinion, every case that's dealt with this is either prior to 2019, where marijuana was the only plant and there was no hemp bill, or the record was missing an expert like Mr. Whitehurst, where the Court of Appeals and the trial court were missing that evidence to rely on.
Sure. So if you want to call your client and he'll say under oath he was smoking hemp in the car, I'm happy to hear from Mr. Whitehurst. Otherwise, he's speculating in the same way that the officers were, and we don't need to make a record on that because the science is the science. They smell the same. And so I don't think it's relevant unless there is some evidence that it was hemp, and the keys to the kingdom are right there. If that's what Mr. Carter's going to say under oath, then we ought to hear from Mr. Whitehurst. Otherwise, I don't think this is the right case upon which to make that record.
Well, I think it is the correct case, Your Honor, because there is a case out there that talks about some different parameters of hemp and how it's processed and different things in there. And I think Mr. Whitehurst can create a record to explain why this is not blanket PC. And I know you didn't hear the entire videotape, Your Honor, but my client never admitted that he possessed anything in the car as far as marijuana. He said others may have been smoking weed in the car, but he wasn't. So I'm not going to be able to put my client up to testify as it relates to that particular substance because he never admitted it was his or he owned it or bought it or any of those things.
Got it. So then this really isn't quite yet the right case for Mr. Whitehurst to expound upon what you want to. It could be the passenger who would come in and say, yep, I was smoking and it was hemp. But right now, the theory that it's hemp is just that, a theory. There's testimony that he was smoking weed. He didn't say hemp. There was none of the, I say testimony, there is in the record evidence that your client said, I was smoking weed, not in the car the night before. He said weed, not marijuana, but in particular, he didn't say, now hold on, officer, we all know there's a difference between marijuana and hemp. And I was smoking hemp, or what was in my car was hemp, or what people were smoking in my car was hemp. There's really no basis other than you'd like to make a record that needs to be made in the right case at some point, maybe through this witness. But I don't find that this is the right case. And I find that Mr. Whitehurst's testimony wouldn't be relevant to what we're working through today.
So, Your Honor, what I would like to do to proffer this evidence for the record, I'm not arguing with the court. Please understand, you're the boss and I understand that. I'd like to proffer D1, D2, and D3. D3 is the opinion of Mr. Whitehurst, which we need this to be part of our record eventually for whatever case, We also have the opinion of the North Carolina State Bureau of Investigation, which is their GBI, which says the exact same thing that Mr. Whitehurst is saying. And what I'm arguing is that this odor of what could be marijuana and hemp is the same, and therefore it's not probable cause to search a vehicle. And I'm summarizing, of course, Your Honor.
Sure.
So I would like to proffer D1, D2, and D3 as what our expert would testify to, and that there was not probable cause based on this odor of cannabis, which could be legal or illegal depending on which one it is.
Got it. I think that's a fair middle ground. I'll admit D1, D2, and D3 to the record for purposes of wherever this might go, depending on how these two cases play out. That will give you the toehold you're entitled to if the way this plays out is that there's an appeal. Then you'll have that to rely on insofar as you'd be challenging my ruling to exclude the testimony of Mr. Whitehurst.
Yes, Your Honor.
Okay.
And just so I'm clear, D1 is Mr. Whitehurst CV. D2 is the opinion letter of the State Bureau of Investigation of North Carolina, and that's where Mr. Whitehurst is located. And then 3 is his professional opinion in this particular case.
Got it. They are all admitted for purposes of making this record in the suppression motion.
Thank you.
Thank you. You may.
Mr. Whitehurst, I'm sorry your visit here was shortened, but
The time will come. There will be the right case, and we certainly do need clarity from the higher courts here in Georgia as the whole, I guess I'll call it cannabis for short, situation gets murkier and murkier. You can buy certain things in a store, and certain things, if you buy them, you're in trouble, and others you aren't. And that's not fair to the confusion creates unnecessary risk out there. So I appreciate your efforts to help clear that up.
am I excused?
Well, that's up to the lawyer who brought you in here, but you're excused from where you're sitting right now.
Yes.
You're excused, Mr. Whitehurst. Thank you, sir. I appreciate it.
Do you, Mr. Willis, have any other, what's a thick CV? Do you have any other witnesses?
No evidence, no other evidence for the defense, Your Honor.
All right. Ms. Nix, any argument you want to make, or do you want to rely on the record that has been established?
I think the record is pretty clear. I'll just go through very quickly. It is about as well established as law can be that a traffic offense committed in front of officers is sufficient probable cause for a traffic stop. The odor of marijuana is then sufficient probable cause for a search of the vehicle under the auto exception. The defendant was not under arrest. He was not told he was not free to leave. When he made statements about, I got a gun in the car. I was smoking weed last night. He was not in handcuffs. He was just sitting there chatting with this officer. They were laughing about real estate and trucking and how long it takes to get money out of people. And so it's pretty clear from watching the video that these statements were completely voluntary. He was under no duress, under no threat of retribution. Officers did not give him any kind of expectation of a benefit for talking. They were just talking. So it's pretty clear from the record that this stop was sufficiently based on probable cause. The search was sufficiently based on probable cause, and all of the defendant's statements prior to his arrest are voluntary and therefore admissible.
All right. Mr. Willis, your thoughts on, I see the 3 areas as well. Was the stop any good? Was the search subsequent to the stop any good? And then what do we do about the statements? Of course, if the stop wasn't good, statements aren't coming in anyway. To me, the stop was the least problematic of the 3, but I'm going to give you a chance to respond in whatever way you want to those 3 areas and anything else you want to cover.
Can I approach, Your Honor?
Sure.
I have 2 cases. One of them was my case, so I have the benefit of at least knowing that case pretty well.
Okay. Is that Hill or?
That's Hill, Your Honor.
Okay.
Yes, Your Honor. That is a case that relates to the detention, but I'm gonna start off with the stop.
Okay.
The statute requires that these cars be marked in a specific manner when they're doing traffic stops. This officer acknowledged he was not a traffic officer. So my position is, if there was a safety issue and there's something going on, someone's failing to maintain lanes, someone's going 100 miles an hour, then that may justify one of these crime suppression vehicles that is not properly marked as a police vehicle pursuant to statute. That may justify a stop by them. This expired tag does not rise to the level of a safety issue, and therefore I'm asking the court to find that the stop itself was illegal. And you saw in that video how hard it was to see any markings on the car, and the statute requires these cars to be marked on all three sides and have light bars and these other things. Now, there's a case out there that says that if there's a safety problem in these crime suppression vehicles, and of course, I don't know that it's the exact same type of vehicle, but a car that's not marked properly pursuant to statute, that would not hinder a stop and an arrest. I disagree with that as it relates to a tag violation. And Your Honor, I also disagree with it in general. I think these police cars need to be marked properly. And I think that's why we have traffic units, and this officer in the crime suppression unit should have called a traffic unit if they wanted to initiate a stop on this vehicle. That's my position on the stop.
Okay, and it's an intriguing one. What is your basis for saying unmarked patrol cars cannot execute traffic stops? Because that's what you're arguing. And I've never heard of that. That doesn't mean there aren't 10 cases or 6 statutes that are on point. And you've done the work, so you point me in the right direction.
Your Honor, can I get you that statute in a minute?
Sure.
There's a statute specifically requiring these police cars to be marked properly. I'm going to let Jessica and Jones in my office help us with that while I'm going to the next one.
All right, but you believe that there's a statute that supports your position as opposed to just out of public policy, we shouldn't be encouraging this. You think there's a law that says you can't do that?
No, there's a requirement that these traffic vehicles be properly marked with clear lettering on the sides and the back. And we don't have that in this case. Okay. So the next step is, would the stop be valid? And that's where there are cases that say, well, that officer saw something fail to maintain lane or something that was dangerous, and therefore they were justified in stopping them. My argument is we don't have any danger in this case.
Certainly an unmarked patrol car that sees a guy running from a bank with a gun can stop that car.
Literally.
Not this case at all. The only basis for the stop that's been articulated to me is expired tag. It's about as safe a violation as you can get.
Correct.
Okay.
That's my position.
Okay.
So Judge, I want to move next to the Hill case. The Hill case is an extremely interesting case to me because it applied Rodriguez versus the state. And Rodriguez is a 2015 case, Your Honor, 575.
And you want to talk about Hill and Rodriguez in the context of, was this stop unduly extended? I think that's what Hill, your case, is about, is that a motion to suppress well, that it wasn't a voluntary, I think yours was about whether the consent was voluntary, but either way, it also gets into, was this stop improperly extended?
That's correct.
Okay.
And Rodriguez is really the case, Your Honor. It's 575 US 348. It's footnoted in number 4 in my case, in the Hill case, Your Honor. And that was really the impetus of this entire argument in Oglethorpe County, was that the officer had extended the stop, and the way that he extended the stop was very similar in how this officer did it in this case. It didn't testify, and we really don't have a whole lot of information about it. The officer in that case, Your Honor, just like in this case, after he said, the officer in this case said, I'm not going to write you another ticket for it. That was one of the first things we heard on the videotape. So the stop is over at that point in time. In our case,
is it over, or did we hear even before that the car reeks of marijuana?
Well,
so we've got officers saying, including this officer, Wells, who said, "Woo, I got up to the car and I could smell the marijuana." So isn't that, I'll call it the extender that would let things, you're saying that's what I need to wrestle with?
I don't agree with that.
Okay.
So that's where we're going with this, Your Honor.
Okay.
And we're even beyond, we're going to get to a better spot and an easier spot for the court, in my opinion, in a second. But in Hill, what was so interesting, and they didn't put this in the opinion, I wish they did, there was about 10 to 15 seconds, maybe 20, depending on which version of events you listen to. But it was either between 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, or 20 seconds. That was the entire delay in Hill that resulted in an unlawful detention of him that resulted in even though the client consented to the search and said, sure, you can search my car, they said that was unlawful getting to that point, and therefore that delay was illegal, and everything beyond that delay was inadmissible. I think we have the exact same problem in this case for a few different reasons. One, we didn't hear from the officer himself, and that would have been Officer Bath, the stopping officer, and the person telling my client to walk to the back of the car. So we don't have any testimony as to what his real reasons were in doing that. And that's what this court needs, the real reasons. And that's what Rodriguez says about what the officers are required to prove and what they're required to do. It's not about what they could have done. It's about what they really do and do with the case. The other question we have in this case, Your Honor, that the state did not meet its burden on, they did not show in any way, shape, or form that the officer was diligent and expeditious. Those are the U.S. Supreme Court words, not mine, in investigating this case. We see a videotape of Detective Wells, and Detective Wells is over there talking to my client. We don't have any idea what Detective Bath is doing through this process. We don't know whether he's in the gas station getting a Dr. Pepper. He could be on the phone with his wife. He could be running the serial number on the gun, which is another illegal action, in my opinion. And the reason that's illegal, Your Honor, all of the same issues with general crime control. When you stop dealing with the mission of the stop and you start doing things like running a serial number on a car, getting phone calls from your friends, talking about other things, then that's when the officers are not doing what is required under Rodriguez. We don't have any testimony of what happened between the time my client walked to the back of the car and when Officer Bath found something in the car. So that is the gap in this case that makes the court's job very simple. All the evidence must be suppressed based on, if you just read Rodriguez. But then you look at the Hill case, which brought that to Georgia to some extent. That was one of the first times we've had our Court of Appeals rule on such a short period of time. What I also gave the court was the Campbell case. And in the Campbell case, the police officer in that case asked one question in the middle of writing a warning, is my understanding of the case. And that was a Georgia case in the federal circuit. And Your Honor, what they did was the officer asked about dead bodies, counterfeit merchandise, and a few other things in this spiel that was on the videotape. We didn't have a video in my Hill case. That's why we were kind of putting together the best we could. But the question in the case in Campbell was 25 seconds, and that's documented in the case, an exact amount of time. And the federal court found that was a violation of Rodriguez, but then they applied the law of the case at the time of the stop, which was prior to Rodriguez. So they found that they denied the motion based on that, but they acknowledged that detention was illegal based on the holding in Rodriguez. And Your Honor, we have 18 to 20 minutes. I think the testimony was about 20 minutes while he was at the back of the car before he was being arrested. So we've got a whole lot more than 10 or 20 or 30 seconds that's unaccounted for that the state cannot put together and prove what the officer was doing. And Judge, I clearly will tell you, I'm not the one that made this word expeditious and diligent up as far as what's required. The U.S. Supreme Court was very clear about what is required. The state must prove that they're expeditious and diligent in investigating the mission of the stop. And if they have another reasonable articulable suspicion, then they must be investigating that diligently and expeditiously. We don't have any testimony of that in this case. So I think this case, given the record that we have, is a simple argument for the court to find the state didn't meet its burden. All evidence is suppressed after, pick a spot, 3 minutes into the video, 4 minutes into the video, 5, because we don't know what the officer was doing through that entire process. So I think that's an easy, clean argument. And then, Your Honor, based on our expert that the court did not allow us to testify, I would argue there was no probable cause even if the second officer on scene can some kind of way justify what the first officer did and could kind of prove that all that ties together and the other officer was perfectly expeditious and perfectly diligent, then I still think there's an issue on probable cause, even searching the car, because as you heard on the video, the Detective Bath didn't say, "Can I search your car?" He said, "I'm going to search your car." So I think we've got good arguments on that, but I understand the court's position as far as the record goes. And that's my position, Your Honor, as far as the case.
All right. Do you, through your colleague, have a citation to?
Oh. And Your Honor, the other two cases I mentioned earlier, Kazim and Burrell, where the court was wanting to know exactly what the particular officer did. The Kazim case is 241 Georgia Appeal 175. The Burrell case is 261 Georgia Appeal 677. I normally would have those cases with me, but I can't find them with all the other stuff I brought with this case.
That's all right. I can look them up.
Can you say those again?
I'm sorry.
Can you say those again?
Yes.
Spell Kazim.
Kazim is Kazeem, 241 Georgia Appeal 175. That's a 1999 case. Burrell is Burrell, 261 Georgia Appeal 677. It's a 2003 case. And I don't mind, Your Honor, submitting copies of those to both the court and.
We can look them up, save the paper.
Okay.
But the statute that says you can't pull, you police officer X in an effectively unmarked car can't pull someone over.
So the marking and equipment of law enforcement vehicles is in OCGA 40-8-91.
Okay.
And the definitions are in 40-1-7. Oh, the blue lights, I'm sorry, it's 40-1-7, Your Honor.
Okay.
And if you could give me till Monday, Your Honor, I can send you a very short letter brief of 1 page with that information in it also.
I'm good. Yeah, I'll spare you that time. I just needed the citations so I can then read the statute, see if there are any cases that have applied them to say ghost lettering is forbidden if you're going to be stopping cars for minor traffic infractions, et cetera.
Yes, Your Honor.
All right.
Judge, please do read that statute because I'll just direct Your Honor to subsection F, which states an otherwise lawful arrest shall not be invalidated or in any manner affected by failure to comply with this code section.
Well, I plan on reading the whole thing. I won't skip F while I go through it. I'll also read Hill and Campbell's thick, but I'll read it. And I'm. It does. It's en banc, so of course it's going to be long. But you all have given me lots to think about. I appreciate that. Let's pivot. It's only 4:15, so we've got time at least to switch over to the other case to talk about the suppression or exclusion of the video recordings. We certainly aren't going to get to the immunity part of it, but let's talk about that. And why don't you start, Mr. Willis? You're seeking to exclude videos, and you just need to give me some context to what was made by whom, when, where, and then thank you. I'll hear from, and you may have been planning to call witnesses. I don't know on that one, your motion in limine, but at a minimum, I'd love to get some context.
Yes, Your Honor. So I have received video evidence, some photos, some live photos, I think is what they're called on Apple, where you at least have a very short clip of a video, but it's technically a live photo from the state in this particular case. And the case law is very clear that under, and I'm looking at the statute 1611-62, 1611-67, 1611-68, and Your Honor, all of these statutes are cited in my motion in limine, and I believe in the motion to suppress. So I did what the Court of Appeals told me to do, double up and do it twice, and that way you make sure you haven't missed anything. So Your Honor, the case law, and it was a famous case in Cobb County that Judge Rob Leonard handled. It was the Waffle House case, where I'm assuming the court remembers that case.
Oh, yes.
Because it ended up in Fulton County also.
Or Judge Newkirk.
Yes. So in this case, Your Honor, there are statements from the alleged victim saying that she made these recordings. She was being calm. You can see her phone is facing down at times. It's facing sideways at times. The people are not facing the phone when it's happening. It's obviously inside of an apartment. I don't think there's any allegation that it was in the public view. So I think that all of the parameters of this case law are met as far as excluding the photo, video, audio, all contained in these things that I have perceived. And the alleged victim is here under my subpoena so I can call her to present that evidence if the court would like to hear that today.
Okay, but as I understand it, you believe that they're photos, they're kind of moving pictures because they're Apple Live photos, but it's not a video as in a 30-second shot, but they're a collection of these moving pictures, or it's both?
It's all the above.
Okay.
We've got pictures, there's audio in some, there's no audio in others, and there's videos.
Okay.
So it's the full gamut from what I understand, and you can correct me if I'm wrong, Ms. Nixon.
Well, she's going to get a turn in a second.
Right.
So
Yeah.
there were audio and video recordings made of Mr. Carter, and you're saying it occurred in his apartment?
Correct. In his
Okay.
home.
Okay.
So yes, but it's an apartment, Your Honor, but for legal purpose, I think it's his home.
Sure. I wasn't saying, gosh, because it's an apartment, then there's no privacy interest. It was what you're contending was Mr. Carter. And is that a shared residence at that time, or that would have, as in, it's actually the Ramirez Carter residence, or it was the Carter only residence?
Carter only residence.
Okay.
Your Honor. He had a relationship with the young lady that was there with him. It's also in the videos and photos.
So there were at least three people there at the time. We've got Ms. Ramirez, Mr. Carter, and female number 2.
Correct.
Okay. So I guess the fundamental question for you, Ms. Nix, is do you intend, if they're admissible and not excludable, would you intend to use any of these? Because if you're not, you're being thorough in your disclosures, but we don't really need to work through this.
Judge, we intend to use it for basically 404B. It is not really 404B, but it's intrinsic evidence, so it shows kind of what was going on the entire night in order to let the jury know what the whole story is.
So you believe Ms. Ramirez would say the photos and videos were taken the night of the alleged incident?
Yes.
Okay.
However, they do not include, because she did not take videos of the attack against herself. This is against another person. The other person that was there, I believe her name is Demi. And then there are photos, or the live photos are of her own injuries after the attack.
Okay, those wouldn't be suppressible under 161162. I'm assuming there may be other reasons to keep those out, but you're not talking about photos that Ms. Ramirez took of herself.
You are correct, Your Honor.
Okay.
Now, the ones that are taken in the apartment where it happens to be her on the video, but she's clandestinely video recording what's going on around her, I think that even though it's technically maybe her in the photo, I think they're inadmissible. But when she's taking a flat shot of her broken fingernail, then I'm clearly not arguing this.
Sure, wherever that was, in the bathroom of Mr. Carter's place, her house, the police precinct, that's Ms. Ramirez taking a picture of Ms. Ramirez, and for only that purpose, and not, I'm pretending it's me, but look in the background, you're catching Mr. Carter and Demi doing whatever's going on.
Correct,
okay. All right, so what's your position as to how, Ms. Nix, your position as to how Ms. Ramirez is filming, I'm just gonna call it filming, of the, whether it's of Mr. Carter or just what's going on at his place, how is that not a violation of 161162 and the related statutes?
Judge, that statute requires that it be a private place, and the court defines private place as a place where there is a reasonable expectation of privacy. Case law says that we use the Fourth Amendment definition of reasonable expectation of privacy. I think I don't think that the defense has any reason to disagree with the statement that Ms. Ramirez was an invited guest at this apartment. She was in possession of her phone while taking these videos. I don't think that there's any reason to say that she was, hiding it behind her jacket or anything. I mean, if we can show you the videos, you'll see she's got her phone out in front of her face while all of this is going on. The court does not believe, the court has never held that there is a reasonable expectation of privacy when there is another individual who is there and is an invited guest and who can invade, as it were, the person's privacy. I'm putting that in air quotes. Let's see, Satterfield versus State, which is 27 Georgia Appeals 528.
It's probably not 27.
127. I'm sorry. Says that a person cannot rely on the privacy of conversation when there are other people around. In that case, the person was having a telephone conversation, and it was observed, it was overheard by other people, because there was no request for more private accommodations, anything like that. Because there were other people around, she did not have a reasonable expectation of privacy in that conversation. Further, the Fourth Amendment requires that the reasonable expectation of privacy, or the privacy that that the person requesting it is trying to claim, has to be one that society is prepared to recognize as reasonable. If Your Honor were to come over to my house as an invited guest and decide to take a video of one of my dogs and then post it on the internet, is that a violation of this code section? Of course not. That would be ridiculous. Society is not prepared to create such an unreasonable rule when it comes to the expectation of privacy.
So I'm going to pause your argument. I follow where it's going. I want to pivot back to Mr. Willis, just so we don't keep Ms. Ramirez here longer than we need to. Do you want her to testify? It's your motion, and it sounds like there may be some disagreement as to how surreptitiously Ms. Ramirez was doing what she was doing. The way that Ms. Nix has described the photographs and filming, the camera's right out there, as opposed to the talking to my lapel here. You know better than I do how that played out, but that may be something to weigh in the process. If Ms. Ramirez testifies, I called out Mr. Carter's name and said, "Hey, let me take your picture," and he looked and smiled and she took the picture, you don't have a great argument. I'm confident that's not what happened, or you wouldn't make that argument. But if you all agree that the context in which the pictures were taken is what you all are talking about, we don't really need to hear from Ms. Ramirez, but I don't want to waste her appearance here. If we could, in a few minutes, hear what she has to say. If you were thinking she'd need to be on the stand for a few hours, you're entitled to that. I don't want to prevent that. We'll just need to do it on a different day. And again, not on the immunity side, just on this question of the invasion of privacy.
Your Honor, I think we can do it a lot faster than in a few hours. I think it's gonna take a few minutes. I think we can do it in 30 minutes.
Okay.
Certainly asking her the questions, and obviously we can go from there, but I can't imagine her being on the stand more than 30 minutes.
Okay, well, let's do that because she's here, and I just think that'll help making a record of the context in which the photos were taken. I think I need to hear that in order to meaningfully assess the concern here.
Thank you, Your Honor.
Well, before we do that, can we agree that she was an invited guest at the time? Just so we don't have to get into too much.
She was an invited guest.
She didn't sneak in the place.
Yes, she was invited to the house.
Okay, great. All right. I don't know if you'll actually be getting Ms. Ramirez in here because she's with your advocate, or if she's out there but someone should get Ms. Ramirez in here,
I can
please.
get her.
Thanks.
She just seems like I'm used to it.
Your Honor, just so I'm clear, we're not going to address the immunity motion today.
Correct. So let's not engage with her on that.
Okay, yeah, I'm just making sure I didn't, other things I've got going on, I can release people and.
Yeah. Hello, Ms. Ramirez. Face the deputy.
Right, you swear affirm testimony will give the truth, whole truth, and nothing but the truth, so help you God. So go ahead and see. Say, spell your name for the record.
Anna Ramirez.
Ms. Ramirez, I'm going to need you to speak up so the court reporter can hear you. She's not here in the courtroom. And all we're going to talk about today is the circumstances in which you took some photographs. That's it. There are some other topics we may need to cover on a different day. But today it's just limited to the photographs that I think that you got to Ms. Nix and that she has, as required by law, shared with the defense. And so we're just going to explore the circumstances in which you took those. Okay.
Mm-hmm.
All right. I don't really care who starts. It's Mr. Willis's motion, but you're already standing up.
And Your Honor, it's my witness.
Yeah.
I subpoenaed her.
Okay.
I'd like to start.
Then I'll have Mr. Willis start.
Thank you, Your Honor. Mr. Ramirez, I'm Greg Willis. How are you, ma'am?
I'm all right.
I'm going to ask you some questions related to a fairly narrow inquiry we're doing today.
Okay.
If you don't understand my question, you can't hear me, if there's any issue, please let me know and I'll try and clarify for you.
Okay.
So this case dates back almost 4 years ago, correct?
Correct.
And that was in June of 2020, June 15th, I believe was the date. Is that right?
Yes, I believe so.
Okay. And I've watched a lot of videotapes of you talking to different people and discussing it with, I think, Detective Wareham, and there's a female detective you talked to. And I think you also gave some evidence to someone else. Am I correct on that?
Yeah, I have had to repeat myself.
Okay. So as it relates to the evidence that you provided to the state, I've been provided, some of them are images that are just a straight photo, correct?
Correct.
And some of them are live photos that are kind of short videos. Is that correct?
Yeah, videos.
Okay. And then I see some longer videos in there also.
Yeah.
Correct?
Correct.
Okay. And I think based on what I heard you tell the detectives was that you were doing this, you were recording them despite, and they didn't know that you were recording them. Is that a correct statement?
I don't know if they knew.
Okay. Well, what did you mean when you kept saying you were holding your phone down and holding your phone when you were talking to the detectives? What did that mean? What were you trying to tell the detectives when you were doing that?
When I said I was holding my phone down?
Correct.
I'm not sure.
Did you ever yell, "Hey, Mr. Carter, I want to take your photo or video. Will you smile at me, please?"
No.
Did you ever tell Mr. Carter that you wanted to take a video of him?
No.
Did you ever tell, and I don't know Demi's last name. What's Demi's last name?
I don't know.
Okay. So the other female that was there, did you ever tell her you were going to take a photo or video of her?
I don't recall that.
Okay. So you don't have any testimony today that would say that you got permission from either one of them to videotape them or photograph them, correct?
I didn't know I needed it.
Well, no one's saying you needed it. And I don't know if you've ever asked anyone other than a stranger, "Hey, do you mind if I take a picture?" If you're with friends, you take pictures, and that's what people do. But to Mr. Willis's question, you didn't affirmatively ask Ms. Demi, "Hey, is it okay if I take a picture?"
Is that correct?
Correct. I don't recall.
Okay, and same with Mr. Carter. "Hey, is it okay if I take a picture?"
Yeah, I don't recall.
Okay.
All right. So the next question I have for you is, would you agree a lot of the photos and videos you took, they were not facing the camera, they were facing a different direction, correct?
Correct.
Okay. And who did you provide did you give those to and show these to the first officer on scene that night?
I don't recall. I was in shock. I can't remember that right after my attack. No, I don't recall if I did or if I didn't.
Okay. Are you aware at any point in time where either Mr. Carter or Demi saw you videotaping or taking photographs?
She might have seen me. I'm not sure about him. He was too in another world.
Okay. So you're not sure of either one?
I'm not sure.
Okay. Thank you.
Ms. Ramirez, Ms. Nix may have some questions for you, but I'm going to go in between the two lawyers. Tell me why you were taking the pictures.
Just in case something bad happened or because it's not normal what was going on.
I haven't seen any of the pictures or videos, and that's okay. It's someday I may. But describe for me just generally what was going on that made you think you needed to take some pictures.
I was just uncomfortable with the situation.
But the situation was they were drinking and they shouldn't be drinking. They were smoking, they shouldn't be smoking. They were gambling. They were playing music you didn't like.
No, they were screaming, yelling, arguing, threatening. And at one point he bent her over and was doing something to her face. You know, his back was to me, so I'm not sure. I can't say that he was choking her on the couch, but to me, he was already on top of her.
When you say threatening, were either of them threatening you or they were yelling at each other?
During that morning, he was threatening us and they were going back and forth.
Mr. Carter, was threatening the two women, you and Demi?
Yes.
Okay. So the reason you were taking these pictures was just to, I don't mean to put words in your mouth, is what I'm understanding. It's basically to document in case something went wrong. You wanted to be able to show, here's what went down. You don't just have to trust my memory or my words.
Yes.
Okay.
That's right.
All right. Ms. Nix, questions for Ms. Ramirez?
Thank you, Judge. Ms. Ramirez, did you know Demi before this night or this morning?
Yes.
How did you know her?
I'm not sure exactly where we met, and I was young and probably still in high school.
And when you arrived at Mr. Carter's apartment, did you recognize her and she recognized you?
Yes. Okay. We greeted each other.
And
was Demi about your age or older?
Just a little bit older, I think.
Okay, but she wasn't 30 and you were 18. She would have been within a year or two?
Yeah, I think so. Yeah, should be.
Now, tell the court about when you were actually taking these videos. A lot of the photos in particular, the live photos, are those of you yourself alone?
When you guys say live photos, do you guys mean videos or just a snapshot?
Let's not worry about the live. I mean, they are what they are, whether it's a video or a photo. I just don't want people to get tripped up on the terminology. So just say pictures versus videos.
Okay, so I'm talking about photos or really, really short videos.
Okay.
Less than 3 seconds. What is the subject of those? Actually, you're on cross. The subject of those videos is you, correct?
Yes.
Okay, and why did you take those photos?
Honestly, I was just taking photos.
Were you documenting any injuries that you had sustained?
Afterwards, after I was in yes.
You took photos of your broken fingernail?
Yes.
And you took photos of some bruising?
Yes.
And some scratches?
Yes.
Okay. Now let's talk about the longer videos.
Okay.
There's in particular one in which you can observe Mr. Carter and Demi in a physical altercation. Is that correct?
Yes.
And you already stated when Judge asked you why you took that photo that you were uncomfortable with what was happening, correct?
Yes.
Okay. Were you uncomfortable with what was happening because you were observing someone attacking someone that you were friendly with?
Yes.
And tell the court how you were holding did you record this on your phone?
Yes.
Tell the court how you were holding your phone in your hand or however you're holding your phone.
I was holding it pretty high up, moving it around, pointing it at them.
And when you say high up, would you say in front of your chest, in front of your head?
Even like right here next to my face.
Okay. And did you have anything covering your phone, anything like that?
No.
If someone had gone over, had, looked over at you who was in that apartment, would they reasonably assume that you were taking a video?
Yeah.
I mean, do you
Just
just walk
fine.
around with your phone up high near your face all the time?
No.
Okay. Did anyone ever say, hey, stop recording?
No.
Did anyone say, don't take photos of me?
No.
Did anyone say, this is my private place, you can't be here?
No.
Now, you also said that the defendant was threatening both you and Demi.
Yes.
Was this something that was occurring throughout the time that you were there? Was he threatening both of you during the entire time he was there?
Yes.
Okay. So would you consider yourself to be a part of what was happening?
Yes, of course.
Okay. All right, I don't have any further questions, Judge.
All right, Mr. Willis, do you have any redirect?
I do, Your Honor. Mr. Ramirez, have you reviewed this evidence recently?
Yes, a little bit.
When did you review that evidence?
Probably yesterday.
Did you review it with anyone from the DA's office?
No.
So have you talked to anyone with the DA's office before your testimony today?
No.
Have you talked to Ms. Nix before today?
Yes, I believe so.
When did you talk to her?
Maybe a couple of days ago. I'm not sure.
Okay. Did you discuss the videos with her?
Possibly, but I can't remember.
I mean, you don't remember what you talked about just 48 hours ago?
I had a brief. Oh no. We did talk on the phone. Yeah.
Okay.
Sorry, I think it was two people on the phone. So I was trying to figure out which one because I haven't met them in person yet.
Okay. And what did you talk about with the videos?
No, I just talked about the entire night, honestly. So we
Okay.
did run through everything.
So did you talk about the videos and how you shot them?
Yeah.
You did.
I said I have videos. Yeah, and I turned them in, and they're part of my, of my evidence.
Okay. And there's not a single video that I ever observed where you said something out loud to Mr. Carter or Demi to let them know you were recording. Is that correct, or am I missing something?
Judge, I'm going to object to leading. This is Mr. Willis.
Not a hostile witness, so you should explore what you want to explore, but keep in mind, as you made very clear, you're a witness, so
Yes, Your Honor.
direct exam.
So, Mr. Ramirez, from what I reviewed, I didn't see any videos that showed you speaking out loud saying to Mr. Carter or Demi that you were recording. Am I correct that I've seen all the videos and there's nothing in there that does that?
I mean, I think it's leading, Judge.
No, it's not. The answer is you're incorrect or you are correct, and you can explain your answer.
I think that's correct.
Okay. And I think you explained to detectives, at least two different detectives, that you were doing this without them knowing about the filming. Is that correct?
Object to leading.
Yeah, now you're.
That's fine. Did you explain to detectives that you did this filming without them knowing? Did you ever talk to the detective about that?
I don't recall.
Is there something affecting your memory today? And I'm not giving you a hard time. I'm just trying to understand. We're talking about something that happened 4 years ago, but you talked about the case with detectives a whole lot more recent than that. Is your memory being affected by something today?
No.
Okay. Yet you don't recall what you told detectives back in 2021?
Not your specific question. No.
Would you agree some of the videos, the camera is facing down towards the ground?
Yes.
Okay, why would that be?
One of my, for myself, I think.
Okay. So you weren't doing that to make sure they didn't.
Hold on,
see
don't talk over each other. I think she wasn't quite done. So why don't you finish your answer and then he'll ask his next question.
I think that was a picture.
Okay, and Ms. Ramirez, I apologize. I would look down to write something down and you kept talking and I apologize. That was my fault. I should have been paying closer attention. I wasn't trying to talk over you.
Yeah, I think that was a picture from what I recall.
So you don't remember any videos that you were shooting with the camera facing the floor?
I mean, the camera was being moved around, so at some point it was facing the floor. Maybe of them arguing, I think, at the beginning of the night.
And it was facing the floor, so they didn't know you were filming. Is that fair?
Yeah, at that point.
Check to leading.
I'll overrule, but just open-ended questions.
And is it my understanding that you and Mr. Carter had gone on a few dates? Is that correct?
That's correct.
And y'all been on a date that night?
That's correct.
And you were going back to his house fairly late in the evening, is that fair?
That's correct.
Was that 5 a.m. approximately when you arrived there?
Approximately.
Okay. And is it my understanding that Demi was also a love interest of Mr. Carter?
I mean, I didn't know. I don't know. You know, I just showed up that night. She was there. And I just happened to know her. I don't know nothing about them.
So your conversations talking about their relationship to detectives, where did you get that information?
From that night. But prior to that, I wouldn't have known.
So when you encountered her at his apartment, that was news to you that someone you knew also knew him.
Yeah.
But over the course of the night, with these things that you've been describing, you put two and two together, like, oh, he's got another girlfriend.
Yeah.
But I'm asking about today. You know today that was his girlfriend at the time. You
I
know
know
now. Correct. You know now, as in where we're standing today, correct?
Correct.
Okay. Instead of filming, I'm just curious why you didn't just leave. You said you were uncomfortable.
Okay, when I tried to leave, I was told that, wait, he's going to have to call you an Uber or he's going to call you an Uber. And then at some points I did want to leave, but I was scared of what could happen if I just try to leave a dangerous situation. And I also didn't want to leave her alone. Something in me was just telling me, you know, this is a past friend. And I'm glad she didn't leave because I think I wouldn't even be here. And I'm glad I didn't leave because something could have happened to her.
So the reason you didn't leave was because you were uncomfortable with what was going on, but you were uncomfortable leaving also.
Yeah, I was afraid.
And the videos that you were shooting, they were recording both video and audio. Is that fair?
Right.
Thank you.
Anything else, Ms. Nix?
No, sir.
All right, Ms. Ramirez, thank you for your time. You're free to go. Have a good weekend. Any other witnesses? Mr. Willis?
No, Your Honor.
Okay. Ms. Nix, any witnesses you want to call?
No, sir.
Okay. Well, this helped, I think, frame the situation. I don't think I need the pictures and videos. I'm happy to let someone tender them and I can review them. But other than maybe a little confusion about were you filming downward versus up, I think the parameters I need to work through and understand the case law around it, because I haven't had a 1611-62 motion before, have been established. Mr. Carter's place, so it's certainly a private place, but someone invited to be there. At least I'm dating you, Ms. Ramirez, and then the rest she's testified to. So I think I have the pieces I need, but if there's more you want me to know about Mr. Willis, now is the time to tell me, and then I'll say the same to Ms. Nix.
Can I approach, Your Honor?
Sure.
I've got two cases that deal with the video scenario. And Your Honor, we submitted a memorandum, I think my office did electronically a few moments ago,
Oh,
This exact issue.
so just in is the memorandum.
Correct.
Okay.
And Your Honor, those are the two cases I cite. And I think it's very straightforward that the expectation of privacy, if people are invited, that doesn't change anything. Obviously, the housekeeper that was taping in the Waffle House case was invited. She was in the home. So I don't think that the arguments that the state is making are relevant to in my understanding, at least the parameters that you have to consider as far as whether it's a private place and what's required. So I think that these videos that were taken without knowledge of my client and without knowledge of Demi must be excluded, Your Honor.
What about where the state seems to be heading with one of its theories of I'm in danger? Certainly I can't be precluded from documenting the danger in which I find myself. That's very different from the Waffle House. I'm going to try to make 30 million off of this video. Here is, in case something bad happens to me or someone calls into question what happened, I'm filming this situation. And I'm putting a finer gloss on it than perhaps Ms. Ramirez did, but that is one way one could interpret what she was describing. So it wasn't for prurient reasons. And it wasn't, I'm gonna be able to extort you later on. It was, I'm in this bad situation and I'm gonna do this either to protect Demi or me or whatever. I'm confident there's not an exception written into the statute saying, oh, unless it's a life-saving moment. But that just seems like a odd ability that someone could invite people over and ritually slaughter them, and someone with a camera there, if that person filmed it, that would be excluded. I just don't see that being the outcome. I understand this wasn't a ritual slaughter of anyone either, but there are allegations that things got violent. And so that's just, it's on the spectrum of there's criminal activity. And the law is what the law is, but I'm curious what your response would be. Take my extreme situation. Like, yeah, you know what? Mr. Carter was stabbing her and I thought, I'm gonna film this and I'm gonna get out of there. And that's what she did. She filmed it and she ran. You might file your 161162, but what's your justification? Like how, I guess it's still, there's this privacy interest in not being filmed while you kill someone in your house.
I mean, the statute is addressing the Fourth Amendment. And as we know, if you find a dead body in someone's trunk or you find a kilo of cocaine in their trunk in violation of the Fourth Amendment, it doesn't change. I mean, the dangers and the crimes that you're investigating don't have any bearing on the exclusionary rule.
Yep.
And the statute in this case is clear. And I understand what the witness said today, but I think that she clearly had the opportunity to leave on numerous occasions. And actually some of the video shows that, in that the scenario that she was in. And from what I understand from her testimony, or at least what she's told some detectives, that this went on for 2 hours as far as this entire event. And based on what she told the detectives, Your Honor, I think she made her intentions clear that she wanted Mr. Carter to go to jail. And that's what she told every police officer and detective that I've heard the discussion about. So
okay.
I don't think that there's, I think there's motivation here. And there's also a discussion of a civil lawyer with Detective Waring that we never really got an answer why she had a lawyer. So there may be a pot of gold at the end of this rainbow that we're looking for, because as the court knows, the statute of limitations is told while a criminal case is pending. So that there may be a civil case coming out of this.
Okay. Ms. Nix, I don't know if you've got cases or if you want to add something. You had been arguing, and I followed it, that maybe there's not an expectation of privacy in this setting, and I'll need to work through that. Anything more you want to add?
I'll just note that it is State versus Cohen, which is 302 Georgia 616, which does specifically say that That's
one of the cases that Mr. Willis handed me, so I actually have it in front of me.
Perfect. But it says that a person who might have a reasonable expectation of privacy in a particular area can lose it if they invite a guest therein. And then the whole premise that reasonable expectation of privacy is built upon is the word reasonable. And what you've said today is hitting on what I'm arguing, which is that this situation is not something that society is prepared to recognize as a reasonable exception.
The right to privacy and I'm not saying this is what happened, but this is sort of the flavor of Ms. Ramirez, the right to privacy to beat your other girlfriend and no one can film it.
Yes, that is
Been
not
invited into the room where it's happening.
that is not I'll just read it. That is not a subjective expectation of privacy that society is prepared to recognize as reasonable.
Okay. I don't know what it is, Mr. Willis. You have a knack of getting cases where it's sort of right on the edge of there's got to be more case law, whether it's the smell of burning cannabis, hemp or marijuana, or this 161162. There needs to be, and your cases I haven't read these cases. They may say, you know what, you're out of luck here, but I believe then there need to be some evolution in the law for a scenario, maybe more extreme than what we have here, but where a third party is invited into a place and realizes this person's stabbing this other person. I can't imagine that ultimately, if that went up to the Supreme Court, it would be, nope, that footage doesn't come in. You should have kept your phone in your pocket. So we'll see. You may have more cases that you can say, these are my cases.
Well, in that case, at least the person would have been charged with that crime. And
right.
In other words, this is, I mean, I understand the state's position, but we're not here to defend those charges because we're not charged with those. So that also is a little bit of a bearing. But I think the cases, the Weintraub and Cohen case, are directly on point and will solve this problem for as far as where we are today.
Okay. Last thing from you all, I need your estimate, Mr. Willis, as to how long you think the immunity hearing will take. Not because we're going to do it today, to be clear, but I need to make sure that enough time is set aside for that hearing.
Well, first of all, my wife is going to be extremely happy to hear that, because I told her I might be here till 7 or 8 tonight. So
yeah.
Thank you, Your Honor.
Not happening.
I think it's going to probably take 2 or more hours, but
half a day enough time? Or what I don't want to do is underschedule it. I just had the third setting of an immunity hearing this morning because estimates were a little off and I didn't build in enough time. And so we had a day and a half day and then a half day. And people should have just said 2 days. That's what that adds up to. So a half day, meaning that 3 hours, and I'm going to hear from Ms. Nick. She may say, well, I have 2 hours also. 2 + 2 is 4. So then that's more than a half day.
I have another proposal for the court. Can you give me till Monday at 9 a.m. to give you a better estimate?
Sure.
And I think at that point in time, I can better, I just haven't looked at the length of the videos closely as far as what may or may not be played.
Mm-hmm.
But if you give me till Monday morning at 9 a.m., Your Honor, I think I can report back by email and give you a lot more accurate answer.
Okay. Ms. Nix, Mr. Willis will copy you on that, and then you should add to it. The state will need an additional X hours. Yes, and then I can do the addition and we'll figure out what we need. Does that work?
Yes, sir.
Okay, great. So we'll look Monday morning for an email from Mr. Willis, and then we'll wait to have, because you may be in trial Monday morning, but maybe you've got an update on Hinton. And then you can add in your part of the time estimate. Excellent. Mr. Carter, you got any questions for me?
No, Your Honor.
All right. Well, thank you, everyone. I will take these two under advisement. I have as exhibits the body cam video, 3 defense exhibits that are for record purposes only that would have come in through Mr. Whitehurst. And there are no exhibits with the 161162 motion in limine. There are some cases that I was handed. I think that's the record. Anything else, Ms. Nix?
No, sir.
All right. You seem fascinated by what's on your screen.
I was just confused because I had not received an immunity motion, but now I see that it was along with the 8,000 other motions that were filed in this case. So.
Okay, I don't know about 8,000, but it was in there because I remember bringing it up and you said, I don't think there's an immunity motion. I'm pretty sure there was in this case, certainly not in the traffic stop, but on the other one. So we'll work through that. Mr. Willis, anything else?
Your Honor, I just want to tell the court, I indicated in my civil service, I was going to serve Ms. Nix in person today with that memo that I filed. I can't find my in-person. Do you mind, Ms. Nix, if I send it to you by email, the memo that was filed under 16, under the privacy?
Did you file it in
A few moments ago, yes.
So she should get once it, I mean, the fact that it was filed, it won't get processed for a little while. But the clerk's office is able to process e-filings and then Ms. Nix will get one that way.
I just want to make sure that.
It looks like I have it.
Perfect.
Look at that. Excellent. Okay, great. Well, we're done. Ms. Rivers, we're off the record. Thanks for your time. And Ms. Nelson, have a great weekend.
And please tell Ms. Nelson, thanks for her help and her kind words. She was asking about my health the other day and I appreciate that.
Great.
You have a good weekend too, Judge.
All right.